Good morning, everyone. Welcome to the first day of this panel's January 2026, believe it or not, case call. I'm Judge Boonstra. I'm pleased and honored to be sitting with Judge O'Brien and Judge Young this month. Judge Young, the second month in a row. As always, I want to give you a couple of points before we begin. Just a reminder that we have been studying your cases for some time. I think you'll find that we are very familiar with your cases, both the facts of your cases and the legal issues that are presented. So we always ask that you keep that in mind when you present your arguments. You don't really need to start from the beginning. We know your cases, so just kind of cut to the chase and get to the significant points and why you believe you should prevail. And I think you'll find that we're up to speed and right with you as you argue that. We have some cases where there are multiple parties on a side, please keep in mind that you are sharing your time that's allotted to that side. So maybe when you come up, you can describe how you plan to divide up your time so that we can keep track of that. We do have some cases involving minors, so children. So please, we really try to protect their privacy interests. These proceedings are broadcast, and so we ask that you use their initials rather than their full names. Anything else? I think with that, let's just go to item number one. Case number 376755, People versus Floyd Russell Galloway Jr.
Morning, Your Honors. May it please the court. Scott Shimkus appearing for the people. I'd like to reserve up to 5 minutes for rebuttal if it comes necessary to that time.
Thank you.
So, Your Honors, understanding that the issue this court faces is a quite narrow one, whether the TCF Bank and Bed Bath & Beyond evidence would have been inevitably discovered despite a later search of defendant Galloway's home, I'd like to highlight really 3 points. The first is the legal standards that apply. The second is the analogy to Nix versus Williams, and the third is the trial court's mistaken analysis. Quickly to the first point, the 2 legal standards here that are so important are, one, the standard of review, which is de novo review, and the second is the evidentiary standard that applies is preponderance of the evidence. So we're talking about pretty forgiving standards here that the people more than meet here. Even if the standards were higher, we would meet them here, that there was inevitable discovery in this case.
So let me just probe you a little bit there, because I noted that you said that in your brief as well. You have the burden on a preponderance of the evidence standard.
Correct, Your Honor.
And as I recall or understand, you're not contesting at this point, at least, the validity of the seizure of the wallet. What you're saying is, regardless of that, the TCF information and then the Bed Bath & Beyond information would inevitably have been discovered regardless of that, right?
Correct.
So what is the evidence? I understand you argue that, well, as part of the investigation, we subpoenaed 12 financial institutions, and we would have extended that to find TCF as well. But what's the evidence you can point to that would have occurred? Evidence.
I think it's a few things. It's the overall timeline of the investigation to begin with. So the investigation starts on December 2nd when Danielle Sislicki first disappears. Within a week of that, December 9th is when this tainted tip comes in. But that same day before that starts this financial canvassing. So Detective Mertes looked at 12 financial institutions, 5 of which were the largest in Michigan, and the 12th on that list was TCF Bank. So he's soliciting these banks, trying to find where Mr. Galloway might have accounts, so that he can find out where Mr. Galloway was spending his money to possibly find out where Danielle Sislicki was. Because again, remember at this point, she had been missing for only a week. She might have still been alive at that point. So they were trying to find her. And we have this information from the preliminary examination and the 2022 evidentiary hearings, this testimony about, timeline. And search warrants are especially important here too. The sheer number of search warrants in this case, 79 over the course of this investigation, about a dozen of which had been executed before this December 13th search that resulted in finding the wallet and the TCF bank card, and 60 some warrants that came after that. So it shows the tenacity of this investigation, that they were looking for Danielle, and part of that search was that they were looking for Galloway's bank accounts. And so if they had been searching for a dozen already, and then subsequent more after that, there's every reason to believe that if it wasn't for finding that wallet and the card and that December 13th search, that they would have simply picked up where they left off. Just like in Nix versus Williams, that they had this grid laid out, they were searching, and if it wasn't for the defendant telling the officers where the body was, that search would have continued and they would have found the body. It was essentially within the area to be searched. That's what the case says. And TCF Bank here was absolutely within the area to be searched, this list of financial institutions. And that's one of the things that the trial court faulted the people for here, is that they said, well, how would they have known about TCF Bank? Well, TCF Bank was one of the largest in Michigan. Of course they would have known about TCF Bank. They just hadn't, because they hadn't looked there yet, doesn't mean they weren't going to.
But you're asking us to assume that because they were conducting a good and thorough investigation, they would have done that, right?
But if I can push back on that a little bit, it's not just that it was a good and thorough investigation. This was one of the most thorough, frankly, at least I have ever seen. The sheer number of warrants shows how tenacious the police were here. This wasn't, and not only that, but the infancy of the investigation at the point when they were looking at these financial institutions. This wasn't years down the road. It was hardly weeks down the road. It was less than 2 weeks down the road. And so there was no signs that they were letting off the gas anytime soon on that particular point, not just the investigation as a whole, but on the financial institutions in particular. And so because TCF was so likely to have been found at some point, probably pretty quickly, because Detective Mertes was continuing to look at these financial institutions, there's every reason to believe that he would have looked at TCF and they would have found that account, and they would have therefore found the Bed Bath & Beyond evidence as well. And so the specific evidence we're looking to be admitted here is the transactions that Mr. Galloway did. And now it doesn't even have to be all of them, I wouldn't say, because the other three of the four that corresponded to the time of Danielle's disappearance really didn't yield any information. But that Bed Bath & Beyond evidence, that's what the jury should be entitled to see here, because TCF was so inevitable. Just like in Nix, they would have continued their search, and the area to be searched was all of the banks in Michigan. I mean, at least the largest ones, the 12th of which was TCF, as we pointed out in our brief on this list of largest banks from September of 2016. This isn't even a recent article. And as we pointed out in our brief too, there were TCF banks near Mr. Galloway's home. And so the inevitability of it is the prominence of that bank and the search that had already started 4 days before this search of Mr. Galloway's home that found the wallet and the TCF card. So it's all of these things, Your Honor. It's the timeline of the case as a whole, the investigation, the number of warrants, and the short amount of time between the initial canvassing and the search that's essentially mooted any need to keep searching because they found his accounts. So the last point I'll make, Your Honors, is about the trial court's mistaken analysis, that there was not much analysis to go on here. The court essentially said, well, because there was no mention of TCF before, it necessarily could not have been inevitable that they were going to find it. But that sort of begs the question. They didn't have to know about TCF before they found the card because, well, they found the card and so they stopped searching. So the trial court's analysis is just, it's a little short-shrifted, perhaps. It didn't sort of go all the way. It didn't fully embrace the people's points here about this true inevitability. And the final point I'll make, Your Honors, is we do have a trial date currently set for February 2nd. And so we would ask for an opinion as expeditiously as the court could allow, just in the event that the losing party does appeal up to the Supreme Court.
Thank you for that reminder.
Yes.
We're pretty quick, but we'll keep that in mind.
Thank you, Your
Try to
Honors.
meet that. Response?
Good morning, Your Honors. May it please the court, Melissa Kraskoff on behalf of the appellee in this matter. Mr. Galloway, I don't typically say a whole lot at oral argument because I think, you know, the court reads our briefs. We don't need to repeat those things. And I think most of the points that were made by the people here today were covered in the briefs. I will say this, though. I'm disturbed at the extent to which the people are asking this court to take Nix in this case. And particularly in this case. This case is a very unique set of circumstances. And what's happening here is not occurring in a vacuum. It's occurring amongst this sea of misconduct that occurred that resulted in numerous other pieces of evidence being suppressed due to constitutional violations. So I think to say, well, there was this good and thorough and straight investigation happening and the police would have found this anyway, is ignoring everything else that has already happened in this case. This case has already been up in front of this court once before, where other pieces of evidence that were suppressed by the trial court, that suppression was upheld. I don't think that this case is fairly akin to Nix, where there's a physical grid, a physical map where you can point to and say, this is the area they were searching. I also don't think that the trial court can be faulted for what the people are calling its lack of analysis when what the trial court was handed was an assumption. The trial court was asked to accept the assumption that the police would have eventually stumbled upon this bank anyway, or this information anyway, without any evidence other than the say-so of the people. There were other financial institutions being looked at. This was not one of them. And I think when you consider that this is also happening in a context where the people are acknowledging that there were constitutional violations on this matter, I don't think that you can say that there was not police misconduct here or government misconduct here to be disincentivized by engaging in this behavior and in what happened here. So I don't have anything else to add to the pleadings I've submitted, but I am happy to take any questions if the court has any.
Thank you very much.
Thank you.
Mr. Shimkus? As you're coming up maybe too, I just want to ask you a question about something you said earlier.
Of course.
Help clarify things. I think I heard you say something about TCF being number 12. Did I get that right?
Yes, Your Honor, yes.
And what did you mean by that they were number 12? Number 12 of what?
On the list of Michigan's largest banks that
Oh, okay, but they weren't like number 12 on the list of banks we're going to subpoena or
that's
anything like
correct.
that. Okay.
Yes, I appreciate the clarification. Yes, it was as part of the article that we had cited in our brief.
What I'm struggling with is how, like, if I think about this on a broader scale, this would seemingly imply that it's sufficient to meet preponderance of the evidence when the people come forward and say, for inevitable discovery, we are in the process of doing a thorough investigation that includes financial institutions. So in every, no matter what the warrant says for the search of a home, you snag a wallet, you find some additional information that's a boon to your investigation. And the inevitable discovery is we check financial institutions as part of our, like, that gets repeat. There's nothing unique about, like, yes, I know in your opinion, this is a uniquely great investigation, but that rising to preponderance of the evidence here means that that exact scenario can be duplicated no matter what the circumstances are.
So I, Judge Young, I would agree with you if the situation was such that the investigation had not already started any sort of financial canvassing, or perhaps even if they had checked only maybe a handful of banks, maybe one or two or three banks or something along those lines. And then they find this wallet and they say, oh, inevitable discovery, we would have found this particular bank. But I think what's unique about this case and why this is inevitable here is because of the sheer number of banks that they had already checked and this very tight timeline from when they had started checking to when they had found the card in the search. It's not simply that, well, as a matter of course, within these types of investigations, sometimes we check financial records, or even most of the time we check financial records. Here, it's that they did check financial records, and not just a few, but they checked more than a dozen. And that and the rest of the investigation shows that they were going to keep doing that until they found his account, wherever it might be.
How is that not exactly what Judge Warren said, which is you've checked a bunch of financial institutions, none of which are TCF?
Well, I
It
think
makes me think that the discovery would not be inevitable because you have not gotten to it.
I think the problem there, Your Honor, is it, as I said before, it sort of begs the question. If TCF was sort of, if they already knew about TCF, they would have checked TCF. And so for the lower court to say, well, it can't be inevitable here because they didn't already check TCF, that it's sort of backwards, if I'm making sense. Just be
Backwards so much as it's just not enough to reach a preponderance. Like if there were an investigation that said, like, this is I think what Judge Warren was saying is this is different than the police saying, we've narrowed it down to 2 institutions and we haven't gotten to them yet. We're between TCF and Bank of America, both of which are in here, this general geographic area to pull from NICS. But that's not what happened. There's a list of the most common banks in the state of Michigan, and they're just being checked off one at a time.
And that's exactly the point, Your Honor, that if they're being checked off one at a time, TCF was in that pool, and so they would have gotten there. I think that's the point, is that it's in the pool, it's in the grid, right? The grid consists of well, at least the largest ones, of which TCF was. And I think
They discovered a bank card for Independent Bank or mom and pop credit union. Because it's smaller and not breaking the top 12 in size, you would not reach preponderance of the evidence.
I think it would be a harder case. I will.
So it's because
I will
of
grant you that.
TCF's size and number of users in Michigan that you reach preponderance of the evidence in this case.
I don't know that it's because of that, but it's certainly a contributing factor that raises us over that preponderance standard. Yes.
Can I just follow up again?
Of course.
I'm sorry.
No, please.
So is it simply a fact that we know today that TCF is on the list of the top 12 or something like that, and we can argue, speculate, whatever we want to call it, that they would have gotten there in the investigation? Or is there evidence in the record that in this particular case, they were focused on systematically going toward each of the top financial institutions? Is there evidence that they were going to do that? Or simply assuming that because they were in the top 12, we know that they would have gotten there?
There is evidence of it because of the list of institutions that they had already checked. So they had checked the big banks on that, at least 5 of the big banks on that list: Chase, PNC, Comerica, Flagstar, and Citizens Bank. And again, because they had checked those, there's every reason to believe they would have continued to check those bigger banks.
I think that's the every reason to believe. I think to get to your point, where's the evidence? Why do we have every reason to believe? Did you present something to Judge Warren that said, we've printed the list of top 12 banks in Michigan. Here's 5 that are crossed out. We're about to do the next 5. But or are you just saying if we look at the ones they've tackled, they're in the top 5. They were clearly doing this. Ergo, it would have happened. Was it the first one where you had documentation? Here's our plan. Here's the top 12 banks in Michigan. We've crossed out 5. We're moving on. Or is it the second one where you're like, they've already searched these 5. Those are really big. And so they're going to continue with really big ones, of which TCF would eventually come up.
It is the latter, Your Honor. Yes. I'm not trying to hide anything here. That is the argument. Yes. That they would have gotten there because of the work they had already done before. It shows the path that they were on. And the search took them off that path. It essentially made it moot that they continued on that path. But the path was straight. It was the largest banks by the evidence we have in the record. And so if they hadn't found TCF before, they would have gotten right back on that road and continued straight down that path. Yes.
Else?
I believe that is all, Your Honor. We ask for reversal and to admit this evidence. Thank
All
you.
right, thank you both. Very well done. Appreciate your arguments.
Thank you, Your Honor.
Case is submitted. Moving to item number 2, case number 373384, People versus Paul Wendell Russ. We have granted oral argument to the appellant, so both parties are endorsed.
Morning, Your Honors.
Good morning.
May it please the court, Michael Desi. I'm appearing on behalf of the defendant appellant, Paul Wendell Russ. Your Honors, this case, as you're aware, comes back to the court on remand from the Supreme Court as if on leave granted. I think the issue in this case is very straightforward, and I think it's fairly simple. Not to simplify the fact that this is a 42-year-old murder conviction, and it's obviously very important to my client. So we have new evidence that was presented to the trial court. The trial court had to go through essentially a two-step process of analyzing the credibility of that evidence under the Supreme Court's decision in Johnson. The Supreme Court tells us that under Johnson, if evidence is not patently incredible, such that it could be believed by a reasonable juror, then you proceed in the Crest standard. The trial court found that we satisfied all 3 of the first steps of the Crest standard. The last step of the standard is, would this evidence make probable a different result on retrial? That's where the trial court abused its discretion. Why? Because it already found that the new evidence was not patently incredible. But then when it applied the 4th factor of the Crest standard, it said, well, no reasonable juror could believe this for reasons that all stem from credibility determinations. Well, this new witness didn't come forward for 40 years. That's simply a matter of credibility. That's for a jury to decide. It certainly, if the evidence could be credited by a reasonable juror, which the trial court found that it could, then the only question left is, could it make a different result probable? And, you know, it has to make a different result probable because you have a new witness who came forward who said, I was there. I was here at the scene of this crime. I was in the car with the victim who was shot. And he says, I know who did it. It wasn't the defendant, Mr. Russ. It was somebody else. And he gave details about that. So that's where the trial court abused its discretion. It simply circled back on credibility considerations on the 4th factor of Crest. And
But
I also
the judge also talked about other factors.
Sure.
Such as the fact that the defendant had tried to injure the victim twice before the shooting.
Okay, so that just goes again to the credibility. You put those, you put
No,
all
that's
those.
not, I mean, that's evidence that came in.
Well,
Yes, away.
Sure, but what Grissom tells us and what the case law says is that we have to now consider all of the evidence at the first trial along with what the new evidence would be. So what we would have would be the evidence that Your Honor just pointed out alongside a witness who says, I was there, I saw it, and it wasn't him. So certainly that has to lead to the conclusion that it could come out differently on retrial. It could make
Plus the fact we also don't have the primary witness from the first trial living any longer.
Sure, well,
correct?
that's
So-
true, but that's not of anyone's fault. It's a 42-year-old murder case, and the witness who came forward also has failing health issues. So, I mean, this is simply a matter of, if the Supreme Court tells us we're supposed to analyze credibility under Johnson, the trial court did that and found that we passed the hurdle of Johnson's credibility standard, that this witness was not patently incredible, but then simply substituted its own judgment on credibility. Well, this individual had kids with the defendant's sister. Again, that's just a credibility factor. That's just cross-examination. The prosecution would be free to cross-examine that witness at a retrial, and then a jury would then be the decider of those facts to decide whether they're going to accept that testimony or not. But if the evidence is not patently incredible, it has to make a different result probable on retrial when you have a witness who was present who says it wasn't this defendant, it was the other defendant.
I
So
wanted, oh, go ahead.
I think I was going to ask your question.
Oh, no, you
I
go.
was just going to.
There you go.
The trial court made one statement that we think was not correct, and we wonder if you can maybe shed some light on it. And that is that the trial court characterized this as your client's first motion for relief from judgment.
Yeah.
I think there was one denied in 1997.
I agree.
What do you know
with-
about that?
Well, I do know that he filed a prior motion, and I did read that last night in the opinion, and I don't think I caught it previously that he said it, but I don't think it changes the equation. The evidence that was raised in this 6,500 motion was not available at the time of the previous motion. So I don't think it changes the standard. You still have to meet that standard of the CREST standard for.
Do you know what was raised in that motion? however?
I don't remember offhand what was raised in that motion, Your Honor. But I know it did not include these facts because it's always a part of my analysis to make sure whatever the new evidence is was not previously raised in prior motions.
Did it include any claim of actual innocence?
I think the defendant's defense had always been an alibi defense. So I think you could certainly read it as actual innocence in the first one, but based on a different theory, not the new evidence.
And the fact that the trial court apparently didn't have any of that information shouldn't matter to us.
I don't think it matters at this stage because we're simply evaluating this piece of newly discovered evidence. And if this piece of newly discovered evidence is not patently incredible, then I think we have to answer the fourth factor of CREST. And that's where I don't think the abuse of discretion standard saves the trial court's decision. And people say, oh, it's an abuse of discretion, so they have a lot of discretion to do, to decide this one way or the other. But it doesn't save the trial court's analysis from misapplying the factors. And I think it's quite clear and obvious that the trial court, once it satisfied the Johnson standard, it simply circled back on credibility when it decided the fourth factor of CREST. I just think it's that simple.
There's no world in which what was filed in the first motion would affect the credibility. Like, to Judge Boonstra's question, here's my concern. Like, what if in 1997, there's this is filed that says something that contradicts the affidavit of, I'm sorry, I'm blanking on his name, but the new affidavit.
Jackson.
What if it's alleging someone else? I heard someone else did it. You know what I mean? Like, what?
Yeah.
It's just so bizarre to me to have this thing exist in the world and the trial court have no knowledge of it, and just to be like, well, fine. And I agree, the affidavit stated when it stated, that's obviously past 1997. I agree with all of that, but I just have concerns about having no idea what was raised in the first and how that could affect, but maybe I'm wrong to think it could affect any part of this analysis.
So I guess, Your Honor, to answer your question two ways. First off, I would say the prosecution certainly didn't raise that and make any argument about why whatever was raised in that 1997 petition would have affected the credibility determination of Mr. Jackson's affidavit. So I think it would have been incumbent upon them to say, well, this prior petition raised some interesting points. And I've had cases exactly like that, Your Honor, where the prosecution has pulled out prior 6,500 motions and they've said, well, in this prior motion, you said this, and now you're contradicting it. That may be true in certain instances, but in this instance, I don't believe it was true. But more importantly, it still goes to the fact that the new witness was discovered well after the conviction. And I still think we're bound to follow the Johnson and CREST standard. So if there would have been something in there, number one, the prosecution certainly didn't raise it, and I think it would have been incumbent upon them to do so. But number two, the law says we're supposed to look at the actual trial evidence, not what someone may have submitted some affidavits along the way in the years preceding. Those were not, if they weren't trial exhibits or trial evidence, I don't think you put it into the bucket of, okay, so what is the evidence now that we look at what was offered at trial?
Yeah, I don't think so either. I'm just curious for the credibility point. And there's a world in which maybe it could have helped the credibility. Maybe it's your client saying, I think there's a person out there who knows I need an attorney, whatever, it's just bizarre to me to be here to read this and the trial court have no knowledge of that.
Yeah, I don't want to repeat myself, but again, I just think it would have been incumbent upon the prosecution if they thought that undercut the credibility or the Cress application of the factors. And I think that it would have been incumbent upon them to raise it.
Then I want to talk to you about the Cress two-part analysis. So the first part is the credibility, which I agree with you. The judge says this person is not totally incredible, or however they phrased it. And then the second part is the court has to consider the this in the context of the evidence that was submitted at trial. And to Judge O'Brien's point, the judge does say it's not just the testimony from Mr. Kirk. It's defendant had an ongoing dispute with the victim and twice attempted to harm him before the shooting. And then there's when the police attempted to arrest the defendant, the door to the home was barricaded and defendant fled while not dispositive by themselves. And then gets back into credibility. But with those two pieces of context, okay, you behaved in this way when we went to arrest you and you have a strong motive. Even if we agree with you, right, that doubling down or redoing the credibility analysis was improper under Johnson, is there enough other stuff there?
Yeah, and Your Honor, so I'll answer your question this way, and I keep seeing this a lot in these 6,500 cases, and I say it in nearly all of my briefs, I think universally. The standard is not a sufficiency of the evidence, and respectfully, I believe that the court continues to look at these cases and asks, is there sufficient evidence to support this conviction? And that's simply not the question. We don't say, what is all the inculpatory evidence? Well, that's enough.
I don't know. It's so much, and that's fair and well taken criticism of the court, but or feedback to the court, but we have to look at the whole landscape of trial. And this was some of the evidence that came
Sure.
in. So there's also that reality.
I agree, but that evidence at best is circumstantial. It's thin evidence when you compare that to an eyewitness who says, I was in the vehicle with the victim when he was shot. I saw the person who did it. And the person he identified was a very bad guy who was taking out, according to him, life insurance policies on drug addicts and having them killed. So he said, look, I know who did it. It wasn't Paul Ross. It was this other guy. That evidence, in my opinion, is stronger. Now, I'm not the jury and the court's not the jury, but what I'm saying is I think that the court has to allow for the prospect that a reasonable juror could certainly credit the testimony of the new witness over those other pieces of circumstantial evidence.
So is the issue that, so the court redid credibility, shouldn't have. And then there's these two additional pieces of evidence that's discussed. So is the problem that there's more to trial that the trial court didn't consider? Like, to your point, this feels like sufficiency. Is there inculpatory evidence? Okay, so is there more at trial that the trial court missed?
I don't believe so, and this prosecution certainly doesn't bring it out. And I won't speak for sister counsel. She's very able and capable of making her own argument, but they certainly didn't point to other facts at trial that would have undercut it. And so, the trial was, and I know I provided the transcripts to the court, so the court has the complete trial transcripts. But the evidence at trial was very thin, other than Mr. Kirk's identification, which the Court of Appeals found back in 1985 or 86 on direct appeal that the identification was coerced by the detective. So a jury on retrial would hear that the only witness who identified the defendant was coerced. And the Court of Appeals agreed with that. They found that they allowed it and found it to be harmless, but it still was coerced. So you have a witness whose identification of the defendant was coerced. And now you have a new witness who's saying, I was there, it wasn't him. And then you have this other evidence about, well, he got in a scuffle. There was a neighborhood beef between him and this guy before. It's just simply not enough to say that this new evidence could not make probable a different result on retrial.
And that argument is specific to this case. You're not advocating for a rule that says once you find a new person credible, you must then grant a new trial. It's because this case is the way it is.
Sure. I don't think it's a per se rule. No,
Okay.
I don't. But
if there's a gun with Ross DNA on it, we're in a different boat.
Sure. And
Okay.
let's not forget the Cress. We talk about the Cress standard all day long. Let's not forget Cress lost. Okay, he lost at the court. He was eventually, I think he was commuted by the governor, but he lost because even with the new evidence that the court said, at least this is how we apply it, they said it couldn't make probable different result because there was overwhelming evidence in the case and the facts didn't line up. The confession seemed to be false and crass. That's not what we have here. We have a single witness who identified the defendant, a coerced witness, and now a new witness who says it wasn't Mr. Russ. I was in the car.
And who are all the other witnesses?
There
When the
was,
trial transcripts came in, I was sort of blown away because of these constant descriptions of it being, like, I thought this would be a 1-day trial. Mr. Kirk testifying, that's the way it was made to seem, but it was like 7 days and 20 some odd witnesses.
Yeah,
What's everybody else?
well, it was, as Judge O'Brien pointed out, there was evidence about him having a scuffle or having a beef with the victim prior, and that he was mad about him dating his sister, or having some relations with his sister or something. I mean, there was other evidence, but none of it was the type of direct identification evidence. And I think that's why both the prosecution and myself focused so much on Kirk's testimony, because it was the only direct identification evidence, and the other evidence was just simply circumstantial. I don't have anything else unless the court has questions for me.
Questions? Thank you very much.
Thank you.
Response?
Morning, Your Honors. May it please the court, Amy Summers appearing on behalf of the people. I first just wanted to mention that I guess I also missed the fact that there was a prior motion for relief from judgment filed, because I always check that and I would have included it in here and it's not in my brief.
It's a
So
long case, right? It's a long time ago.
I'm happy to look into it and further brief the issue if it would assist the court. But I did want to just say, I do think the trial court erred when it found that the witness was not patently incredible, for a lot of reasons. One being that it's just absurd that this person is coming forward so many years later. This person's a family member of somebody in the defendant's family, and to think that he wouldn't have come forward sooner is just absurd. The fact that defendant sought him out to do this affidavit and then wanted to have him change the affidavit.
Did you
and-
change the affidavit?
Defendant had someone go and talk to Scott Lewis about changing the affidavit, but then Scott Lewis declined to change it because, and he testified at the evidentiary hearing that he doesn't normally change affidavits, you know, based on someone coming to him and telling him that they want it changed. I mean, that wouldn't be.
And what was it that defendant wanted changed?
He wanted it to not appear that he had actually sought out the witness to write the affidavit. He wanted it not to appear that he was trying to.
Nothing about the observations of the crime.
Correct. And then there was also, and that was on a jail call that was admitted at the
Mhm,
evidentiary
yeah.
hearing. And then there was also defendant was trying to get someone to testify as an alibi witness. There was a letter in the file that was admitted at the evidentiary hearing. And I just think it's highly unlikely that Kirk would not have told the police that there was someone else in the car. I just think that
Did Kirk have any credibility issues?
um
I thought he testified at trial that he didn't start telling the truth until like the 5th time he talked to police or the preliminary examination.
that might be the case, but it's still, I think he would have disclosed this. It would have been in a police report. It just seems so unlikely that this person was in the car with Mr. Kirk. It's not in any police report. Mr. Kirk didn't mention it before. And now, all these years later, this person's coming forward. They happen to be the defendant's family member. They happen to be coming forward after Mr. Kirk is deceased. And I just think that a jury on a new trial hearing all of this together, it would not make a difference on retrial. And I do think the court got that right when they found that the fourth crest prong was not satisfied, because I do think that even setting aside the credibility of the witness, there was other things that would come in a new trial that would, such as defendant writing a letter to someone asking them to be an alibi witness, such as the defendant trying to get the affidavit changed. All of that would come in in a new trial. And I do think that when you put all of that together, it would be the same result on a new trial. And so I do think the trial court got that right, but I think this court could still find that the witness was patently incredible and that the trial court reached the right result for the wrong reasons.
Can I ask you a question? There's been brought up by Mr. Desi that the testimony of Kirk was coerced. Wasn't the evidence that came in that he was maybe not telling the truth because he was being threatened?
Yes, that's
And
correct.
he actually had a broken leg. Someone had assaulted him over this incident.
Yes, that is correct, Your Honor.
Thank you.
There's no further questions.
All right, thank you. Rebuttal? Yep.
Just to address Judge O'Brien's point, the Court of Appeals on direct review of Mr. Russ's conviction found that Mr. Kirk's identification was coerced by the detective, not that he had been threatened by anybody. And we know that because the prosecution confessed error on that point. So we can't now cure that by saying, well, he then later came to trial and said the reason he lied and that he misidentified someone was because he was threatened by the defendant. The prosecution conceded that and confessed error back in 1985 on the direct appeal that the coercion happened by Detective Gunderson. So that's important. And then Judge.
Isn't it a little bit both and,
Well, it
right?
could be, but-
Because didn't at the evidentiary hearing, it come out that he had sufficient background connections with the defendant to make it a legitimate identification. And he, I think, testified to the fact that he
Sure,
was threatened.
sure.
So
But what-
can it be both?
Sure, you're absolutely right. Sure, but so what we're left with is this whole bucket of conflicting pieces of evidence. It's not for us to pick which ones we want to believe. And again, we're back to, could a reasonable jury credit this testimony? And Judge Young, on your point, you asked Sister Counsel about Mr. Kirk's testimony. He did admit that he lied to the police several times. And even according to Mr. Jackson, he told Mr. Jackson he gave the police a name of someone else when they came and interviewed him and talked to him. He says, oh, I told him it was Boo Bear. So he wasn't credible. But again, it's just not for us to decide who we want to believe. We have a bucket of a bunch of, conflicting pieces of evidence. And I think at the end of the day, once the witness is not patently incredible, then it has to go to a jury on retrial and have them decide. The other thing I wanted to mention about Mr. Kirk's testimony is he did fail to identify the defendant twice at two lineups, both a photo lineup and a live lineup. I think that's important because that's two times that he had an opportunity to identify the defendant and he didn't. And again, the prosecution can confess error on direct appeal that it was coerced by the detective. So unless the court has any questions.
I have one more question.
Yeah,
for
sure.
you. Who's Hazel Gunter? Who's the person,
Yeah.
just to be clear, who
Yeah.
I understand from the testimony, hired Scott Lewis to
Yeah.
do the investigation and who then wrote the affidavit?
So Hazel Gunter was she was Mr. Wendell, Mr. Russ's lady friend, and she passed away not that long ago. She got pancreatic cancer. She was the champion of Mr. Russ's quest for freedom in this case. And she was the one that contacted me. And I will be quite clear about it. She hounded me to take the case, even when I said I didn't want to. And she kept coming to me saying, please look at this. So Hazel Gunter is simply a lady friend of the defendant who helped put in motion getting Mr. Scott Lewis hired as a private investigator, getting him to interview Mr. Jackson, contacting my office numerous times. And
But was she trying to do this for 40 years, or did this just come up 40 years later as well?
I don't know. I don't know when. I don't know I can't give you the lifeline of their relationship. I
Right,
know
right.
that she passed away in the last year. It was very sad to hear. And that she worked tirelessly on behalf of Mr. Russ in making this evidence and making sure that we could at least get to court to have the opportunity to discuss this case.
Any final question? All right. Thank you
Thank-
both very much.
Thank you, Your
Another
Honors.
interesting case. And that case is submitted. Moving to item number 3, case number 370296, People versus Malcolm Colbert. We had one party endorsed and he has waived argument, so that case will be submitted on the briefs. Item number 4, case number 373093, Teresa Poninsky versus David Goldsmith. I believe we have one side has preserved argument, and I believe will be appearing remotely. Oh, one person is, I'm sorry, we got everybody here. Go ahead. Who do we have?
Morning, I'm Douglas Abraham on behalf of the plaintiff appellant. I've waived formal oral argument, but I'm only here if there's any questions.
All right, thank you for being here, and please.
Good morning, Your Honors. May it please the court, Courtney Lavender on behalf of Applee, Mr. Goldsmith.
I'm sorry, I had you down as remotely, so I
Oh,
apologize.
No, that's okay. There was some confusion
Okay.
here with us, but
All right.
I'm just going to rest on my briefs as well, Your Honors, unless you have any questions for me.
Okay. Any questions? Hang on one second. Yes, I do not. Anybody have questions?
No
All right,
questions.
thank you.
Thank you.
Any questions for opposing counsel?
None.
All right, thank you for being here. Case is submitted. Item number 5, case number 372207, Tectera Corporation versus Angela Smith.
Good morning, David Tillman appearing on behalf of, excuse me, plaintiff appellant.
You can be seated and put your appearance on later. Go ahead.
As this court is well aware, this action involves the parties' dispute over the amounts paid in partial performance of a real estate purchase agreement for a house in Detroit's Indian Village. Specifically, the disposition of the amount paid in excess of the security deposit that was tendered after Tectera Corporation breached the contract by its inability to close on a purchase according to the contract's express terms. We believe that the trial judge fashioned an outcome in a case that permits the homeowner seller to retain both the real property and the purchaser's monies paid in partial performance under the contract, which result Michigan law does not countenance. At its core, the defendant appellee's position, Ms. Smith, her position is that because Tectera's president, Terry Barnes, is a bad guy or a grifter, that she should be permitted to retain all monies paid, despite that not being what the contract, the purchase agreement provided. As you're well aware, the contract was very clear, we believe unambiguous, that the earnest money deposit was $10,000 at the direction of Tectera's president. Texas Council wired the amount of $250,000 to Ms. Smith, the receipt of which Ms. Smith acknowledged. That wire transfer constituted the $10,000 earnest money deposit, and $240,000 over that amount represented Tectera's partial performance under the contract. And although Tectera did not tender its earnest money deposit timely, the contract had not been declared to be in breach by Ms. Smith, so Tectera simply had additional time in order to pay. We believe that the trial judge erred in holding that the Tectera was not the real party in interest in the case, as Tectera Corporation was a party to the purchase agreement with Ms. Smith. Defendant appellee makes much of the source of funds that were used in partial performance which we believe to be a red herring. And other than that, I'd rest on my brief unless you have any questions.
Questions? I have none. Thank you very much.
Thank you.
Response?
The honors, Michael Ford is here on behalf of the appellee and defendant in this matter. Your Honor, I don't think it's a very complicated matter as pertains to this case. It was clearly and unequivocally a money washing scheme. Terry Barnes engaged in the misappropriation of these funds in this joint venture.
It's a breach of contract case, right?
Where I'm
The
referring
one,
to.
this present one.
Right, right,
So Tectera was the party for this, the real estate agreement.
right.
And so even if we assume with you that this is dirty money and messed up in all kinds of ways, that might affect their ability to recover from a breach of contract claim, but it doesn't mean that they're the improper party. They were the party to the contract.
They were the party to the contract.
So why does their badness mean affect a breach of contract case at all?
Because they,
Why aren't they the real party in interest? That's
because they never paid any money. That's the issue and as the brief lays out, a corporation is separate and distinct from its shareholders. And our position is that Terry Barnes acted individually, and aside from the corporation, there's nothing to show that the corporation ever had anything to do with the transfer of this money.
But Mr. Barnes did not sign the purchase agreement. That would make him the real party in interest on a breach of contract claim, wouldn't it?
Mr. Barnes did sign a purchase agreement.
But not in his individual capacity, signed on behalf of Tectera, which was the named party in the purchase agreement
That's
as the
correct.
buyer.
That's correct.
So how can Tectera, as the named party in the purchase agreement, not be the real party in interest on whether that purchase agreement was breached?
I guess the issue is whether or not Tectera ever paid any money to Ms. Smith in regards to this purchase agreement. And that's our position. No money was ever paid by Tectera.
Well, I agree that's an issue. I just don't know if it's the issue that's before us, because before us is the issue of who was the real party in interest to the contract, because that's the ruling the trial court made. Right?
Well, I think the trial court made the determination that Tectera had never, as I indicated, paid the money as the contract required. And so, and Tectera had no damages and had no ability to recover the contract, which is the basis for the motion to summon this position. Now, maybe, my interpretation is incorrect, but I don't think so.
I wouldn't think you would.
You got any more questions for me?
No further questions. Thank you very much, Mr.
Thank you.
Tillman, any rebuttal?
I have nothing further.
All right. Thank you both. Case is submitted.
Thank you.
That brings us to item number 6, case number 374174, Tamaya Chantal Allen versus USA Underwriters. Morning, come on up. Well, you have to come to the podium, please. Put your appearance on there, because that's the only place we can pick you up.
Oh, there's no mic over there. I'm
All
sorry.
right.
Good morning, Your Honors. Johnny Hamoud on behalf of the plaintiff appellant in this matter. I'll rely on my briefs and reserve my any questions you have for me.
Thank you very much. Response?
Good morning, Your Honor. Shelby Avery on behalf of the Appellee USA Underwriters. I will be very brief here. There was a material misrepresentation. There's no dispute that it was a false statement. Plaintiff's counsel readily admitted that at the MSD hearing, it was material. We have an affidavit from the underwriter indicating it such. Had they been able to appreciate the increased risk of issuing a policy to somebody with an undisclosed household resident with undisclosed license suspensions, they wouldn't have issued the policy. Under Michigan law, that is immaterial misrepresentation. She made it with the intent that USA would rely on it by virtue of completing the application, by virtue of submitting it to USA to obtain insurance. That shows intent that USA would indeed rely and issue her a policy, which they did. That satisfies the fifth requirement of a fraudulent misrepresentation. And lastly, they did indeed suffer injury by issuing a policy without being able to fully appreciate the risk. And it's USA's position that this court should affirm. Thank you.
I have one question for you.
Yes.
I hate to raise it, but I'm going to raise it anyway. What does it mean in the application when it asks this question? In the past 3 years, have you or any rated household member had your driver's license suspended or revoked? Does that mean, was your license suspended or revoked at any time during those 3 years? Or does it mean, was the action taken to suspend or revoke your license within those 3 years?
Your Honor, it means any time in those preceding 3 years, did you have a license that was suspended or revoked? Meaning, was it an inactive license, either for suspension or a revocation?
That seems to be the way both of you interpret that, but I might suggest that it could use some clarification.
Understood, Your Honor.
Okay.
Thank you. Any other questions from the panel? Thank you very much for your time.
Any rebuttal?
Your Honor, just one brief point of rebuttal. I think we outlined the fact in the brief that the lower court held it was reckless misrepresentation. It's not intentional. I think to your point, a 2019 license suspension that was reinstated in 2021, almost 3 years before the application, I think bodes to the point that it was not a reckless misrepresentation whatsoever. I would just submit that the lower court should be overturned.
What about the other representation, which is that she had no other household members when in fact she was living with her fiance? That one's a little clearer to me.
Your Honor, I would submit that in her interpretation of the question that they were asking for household drivers instead of household members is a fair one.
No.
Thank you both.
Thank you, Your Honor.
Case is submitted. Item number 7, case number 373088, Farmers Insurance Exchange versus Alan Lusk.
Good morning, Your Honors. Gordon Barris appearing on behalf of Mr. Lusk in this case.
Right.
There are really two, I think, pretty straightforward issues in this case involving rescission. First one is whether or not there should be, the judge erred in rescinding it based on unilateral rescission and then based on mutual rescission. The mutual rescission, I think, is very clear in this case. My client received a letter from the insurance company telling him that the claim was denied and his policy was being rescinded because of fraud. It did not state in there, if you cash the check that we're sending you, your policy will be rescinded mutually. It told him unequivocally that it was being rescinded unilaterally. And therefore, simply the cashing of the check, according to the Bradley case that I've cited in my brief, does not constitute a mutual rescission. As far as the unilateral rescission goes, the insurance company must prove fraud. They must have evidence of fraud in the application of this and the inception of this case. The insurance company never submitted the application. There must be a statement made by my client, and it must be false. And I don't see any evidence of any such statement in the record. The affidavit submitted by the defendant, the cross defendant in this case, the insurance company, states that he failed to do this, failed to do this, failed to do that. Again, there's no evidence of any statement or any silent fraud on his part. And therefore, in my opinion, you cannot have a unilateral rescission in this case. The trial court should have granted the summary disposition to my client under 2.116 I2 instead of granting summary disposition for the insurance company. Any questions today?
So the contract is a sort of mandatory prerequisite for to show fraud. There's no other way to do it.
There could be, I suppose, but this is at the inception of the policies we're looking at here. That's the time frame we're looking at. there's no statement by my client that's been introduced that is false. So there is no evidence of such a statement, period. Has been introduced.
There's knowledge of, I think it was on the record, his premium, right? And how it would have gone up in accordance with various answers to the questions. That's not sufficient.
That's not sufficient, in my opinion. You still have to prove a misrepresentation. You can't just prove that the premium go up. That's reliance. That's a reliance factor later on. That's a separate element. You have to prove that there's a statement, that there was a false statement, or that there was a statement that doesn't include what it should have based on a question being posed. So no, just the fact that the premium goes up doesn't make any difference if there's no misrepresentation to begin with. No.
All right.
Anything else?
Thank you very much. You have time for rebuttal? Response?
Good morning, Your Honors, and Happy New Year.
Good
Matthew
New Year.
Nichols appearing on behalf of the Appellee Auto Club. If I reference by way of AAA, it's all within the same party. I guess I'll start with Brother Counsel's second point about their claim that Auto Club failed to produce evidence of misrepresentation vis-a-vis they failed to produce a copy of the application, and therefore there was no evidence of any material misrepresentations. That position ignores critical documents within the record of this case that the trial court judge correctly observed and viewed prior to making his decision affirming the rescission. What are those? There's two main documents. One is the policy under the general conditions, paragraphs 14 and 16. Paragraphs 14 requires that Mr. Lusk disclose his address, where his insured vehicles were going to be principally garaged, who the operators of those vehicles were, who had regular access to the insured vehicles, and the ownership and registration of those vehicles. That policy provision further provided that failure to inform of any changes within 30 days as to what was provided on the application or otherwise amounts to misrepresentations entitling Auto Club to rescind according to paragraph 20 of the general conditions of the policy. The second part is in section 16 of the policy. It incorporates the declaration pages. And this section provides that the statements contained in the declarations pages are those from the insured, Mr. Lusk, and that those statements are the statements that Auto Club relied on when issuing the policy. This shows that the application or the lack of the application in this case in the record is not dispositive and doesn't result in reversal of the lower court judge's ruling in this case. But beyond those two critical documents, the policy and the declarations, what else did the trial court review in the record? The motion from Auto Club was well supported. It was a C10. It had two affidavits, very detailed affidavits, I believe, from an underwriting specialist and an investigator. It had detailed rescission notices sent to the insureds explaining why their policy was being rescinded, what the misrepresentations were, why they were false, the impact on the policy premiums had the truth had been disclosed. Mr. Lusk's own testimony, he admitted that he received the premium or the refunded premium check from Auto Club. And in addition, there were court records from the local 36th district court showing that who would be the innocent third party in this case, on Coleman, who is not a party to this lawsuit, showing that from 2017 through 2023, there were 4 instances of driving infractions where charges were brought in the 36th district court to show, as Auto Club maintained, that Ms. Coleman was a regular driver of the vehicle. In response to Auto Club's motion, what did Mr. Lusk come forth with beyond denials in the pleadings? A single affidavit with 4 lines. And the 4 lines were just mere conclusory statements. There was no evidentiary support or any explanation within his affidavit. Conclusory affidavits, as this court knows, are insufficient to create a question of fact. That's Hamad versus Sunoco, 271, Mich. App. 145. That's a 2006 case. And even if we look at Mr. Lusk's affidavit and what he said, it didn't dispute several of the bases for why Auto Club rescinded the policy. It did not dispute that LaQuanda Coleman's residence was in Detroit. That was a basis for rescission. It didn't dispute title to the 2009 Chevy Malibu, which was part of the policy that insured the Toyota that Ms. Coleman was driving. And it didn't dispute the principal owner of the Chevrolet Corvette, another insured vehicle. So based on the failure to dispute each basis for why Auto Club rescinded, the response to the Auto Club's motion for summary disposition, I think just fell very short of meeting the rebuttal burden of 2.116G. As to the argument that there was no mutual rescission and brother counsel's reliance and attempt to draw parallels from this court's decision in Bradley, this court can affirm because of a unilateral decision. In Bradley, this court refused to affirm the rescission primarily because there was no evidence that the application from the insurer in that case actually asked the questions which were the alleged basis for the rescission or the misrepresentations, which were, I think, who resided in the insured's household and where the vehicle was garaged. So here we have an established record of several misrepresentations being made. The policy clearly permits Auto Club to rescind in this specific type of instance, and that rescission can be unilateral. Bradley didn't say that unilateral rescission is not an available remedy ever. No, it didn't say that. It requires proof of the misrepresentations, the ability of the insurer to rescind as reserved under the policy documents, which were just not present in that case. I know I briefed a jurisdictional argument. I'll rely on my brief on that. I just think it's interesting that when the delayed application was filed, something was filed on October 29th of 2024. To this date, I have no idea what it is. I haven't seen it. I was never served with it upon filing or even after filing, despite asking counsel for a copy of what was filed. This court immediately issued a notice of defect on the filing. So it's our position that even if something was filed within that 6-month window, that it didn't conform to the requirements of MCR 7.205, I think B1 through B6, everything that's required in an application for leave. For those reasons, we ask that the court affirm, and I'd be happy to address any questions.
Questions?
Thank you, Mr. Nichols.
Thank you, Your Honors.
Any rebuttal from Mr. Barris?
Just briefly, Your Honor, thank you. There were cited, brother counsel cited sections 14 and 16 of the policy, which looks like is what they're relying on for the fraud action, since they have nothing, no application from him stating this is the answer to the question about who's driving this car, etc. Paragraph 14 deals with, it says the principal named insured must inform us within 30 days of any changes relating to the following, and it lists 5 things. We don't even know what was in the original application, and therefore they can't rely on any changes being made. It doesn't say you have to, within 30 days, tell us of everything, only if there's changes to be made. You can't ignore that word changes. It's very important. So there's no evidence that there were any changes. The granddaughter was driving the car as she always has been. According to my client's affidavit, she used it occasionally. If you look at also the declaration page, which was relied upon, the declaration page simply says that the names insured here are Alan Lusk and LaQuanda Coleman. It doesn't say either way whether or not there are other drivers using this vehicle and what their status is. So there's no information. Again, there's no statement made by my client as to who else is driving this vehicle. So you can't have a false statement when there's a misrepresentation, when there's no statement made by him to begin with. It's just an utter lack of evidence in this case, in my opinion, as to a statement and a false statement by my client. Therefore, you can't have a unilateral rescission of this insurance policy. To the extent that you think there is some sort of sufficient evidence to at least get through the initial burden, my client's affidavit is more than sufficient. It may be somewhat conclusory, so is theirs. Take a look at their affidavit. Their affidavit says he failed to disclose this, this, and this. There's very little submitted, though, as to what that's based on. The affidavit, for example, says that his granddaughter drove this car on numerous occasions. I don't know what numerous means, where that comes from. Is that something she said? It's hearsay if it came from her. If it's some conclusion that the agent came up with, I don't know what it means. And the policy doesn't speak in terms of what their argument is. It doesn't speak in terms of numerous. It speaks as far as regular use of the vehicle, who regularly drives the vehicle. And therefore, I don't think there's anything in that affidavit whatsoever that goes to the issue of whether there's been a misrepresentation or not by my clients.
All right. Thank you very much.
Thank you.
Case is submitted. Thank you, Your Honor. That concludes our 10 o'clock call. We're going to take a short recess before we begin our 11 o'clock call.
All right.
Thank you for that indulgence. We're going to move right into our 11 o'clock call at this point, starting with item number 8, case number 374-880. Richard, I'm going to butcher this name. I apologize. Sarfo.
Yes, correct.
Versus Harold Sullivan. I believe we have only one. Are you endorsed? Okay. I show defendant appellant endorsed but waived. Why don't you come up to put your appearance on the record for us?
Matthew High for plaintiff appellee Richard Sarfo. So we waived the argument, Your Honor, what previous firm did, and my firm took over the case.
Right. So I don't show you as endorsed. Is that your understanding?
Yeah.
Okay. And Mr. Castmore for the appellant has waived. I don't know if you know that.
Yeah, I didn't know that.
Okay.
'Cause, yeah, I got the automated and it said he didn't waive. I did not know that.
Okay. So he is waived and you're not endorsed. So we're going to submit that on the briefs.
Perfect. Thank you. Your
Okay.
Honor.
Thank you for being here. Which brings us to item number 9, case number 374-141, TIR Capital LLC versus Hush Entertainment, Inc. Again, we have one party endorsed, the appellant, and I believe Mr. Frazier is appearing remotely.
Good afternoon, Your Honors. James Frazier, appearing on behalf of appellant Randy Murr.
Thank you, Mr. Frazier. Hold on one second. I hear you, but I don't see you. You have
Yeah, it's got to get my start my video.
time.
There we go.
There you go. Nice to see you again.
I see you also.
You may proceed.
We were unopposed on this case. The plaintiff appellee had not filed a brief of any sort or filed an appearance. So I'm going to rely on the briefing that I've done, and I will entertain any questions if the panel has any.
I think we have no questions for you, Mr. Frazier.
Okay.
We
Well, thank you for your time.
this, however.
Sure. Thank you. I appreciate it.
All right. Thank you so much. And that case will be submitted.
Thank you. Bye-bye.
Bye. Which brings us to item number 10, consolidated cases 367-753 and 369-354 BTW versus City of Detroit.
Good morning, Your Honors. Josephine DiLorenzo on behalf of defendant, City of Detroit. We are asking that you reverse the trial court's orders and grant judgment to the city, or at a minimum, reverse and remand for a new trial or remittitor. So we have 2 appeals and we raised many, many issues. So I'm just going to focus on a few of them and rely on the briefing for everything else. If I could have 2 minutes for rebuttal.
Okay.
Thank you. So the most straightforward way to provide relief is to reverse the trial court's order denying our motion for JNOB because there was no admissible evidence the driver was negligent. The only evidence plaintiff has is the unreliable opinion testimony from Tim Robbins, who said that the tire would have wobbled and created loud noises that Pennington, who was the driver, would have both heard and felt. But the extent of the facts and data that were supporting Robbins' opinion is that one time when he was driving a 2005 Chevy Tahoe police vehicle with loose lug nuts, he allegedly could hear clunking and feel the wheel moving. So this opinion doesn't satisfy Rule 702 or MCL 600.2955. If you just go down the list.
Did you request or did the trial court hold a Daubert hearing?
So after the 3rd appeal, when this court recognized that this particular issue hadn't been raised in that manner, they had raised it as a question of fact before. So they did on remand ask for, believe it was with a motion in limine, and they asked either to exclude it or to hold a hearing, and the court did not. So, but if you go down the list of all the factors, he didn't identify any scientific or technical principles or methodology on which he based his opinion. Again, it was just the one time he was driving the Chevy Tahoe. He conceded that he didn't take any measurements of any kind. He hadn't done any testing of any kind on the same make and model of vehicle, which was not a Chevy Tahoe. It was a 2009 Ford Econoline E350 van. He didn't test an exemplar tire or hubcap, and he didn't do any audio testing to see if you could even hear loose lug nuts that would be audible inside the same kind of van. And he actually conceded that he didn't do what would be the only appropriate testing. And so that would be to take a van out and actually test different scenarios. And he didn't show that the opinion was generally accepted within the relevant technical community and there was no peer-reviewed literature. So the literature that actually does exist was identified by the city's expert, and it directly contradicted his conclusions. That article said there'd be no warning to the driver, and even a test driver who knows that a wheel is going to fall off would have continued to drive until the wheel fell off. And the articles were based on experiences in multiple different types of vehicles. So this is the same situation as the Supreme Court decisions in Elher and Edry. So it's not just the lack of supporting literature, but it's a lack of any other form of support. And so if you don't have that unreliable testimony, there's no evidence of negligence. So if the court doesn't agree with that, we've also raised several arguments based on the evidentiary rulings that would entitle us to a new trial. And again, I'm just going to talk about a couple of them. Otherwise, we could maybe be here for 4 hours.
There were a lot that you raised in your briefs.
It was a very, very long brief, and there were 2 of them. So, of course, the biggest one is the ruling that plaintiff was unavailable to testify, even though he'd previously appeared for a discovery deposition, and even though he petitioned the probate court for a conservator. So here, it was May 4th, 2023, so that's the same month as trial. The probate court appointed a temporary conservator. A full hearing wasn't scheduled until May 30th, so that was in the middle of trial. But the point is that a conservator is defined as someone who manages a protected individual's estate. And in this case, the conservator, his powers were limited to just assisting with the trial and preserving any assets. So if there was a question of mental competency, then it should have been a petition for finding incapacity and the appointment of a guardian. So it's not the same. It's also somewhat inconsistent because if plaintiff's petitioning for a conservator, that kind of contradicts his position that he was unable to testify. You have to be mentally competent to petition for a conservator. So that just says that he was mentally capable of appearing and testifying. The trial court did also point to the guardian ad litem report, but that just said that plaintiff was having problems with his memory and he needed a conservator to help him handle the lawsuit. There was also concern about seizures, but the city offered that he could testify from home. But instead, we have this finding of unavailability And that was just fundamentally unfair. It deprived the city of its right to cross-examine him and to let the jury see for itself how his injuries supposedly affected his ability to lead a normal life.
And that ruling came on the fourth day of trial, is that correct?
Correct. I was about to say that this sort of dovetails into the surveillance issue because this ruling that's important, it came on May 26th, which, let's see, 22. Yes, fourth day of trial. I can do math. So the city promptly went out and got surveillance that showed that the plaintiff was perfectly capable of walking himself to the party store and socializing with other people. So the city disclosed the photographs and the video to plaintiff's counsel and to the trial court. You know, they filed an emergency motion. They wanted to amend their witness list so they could add the private investigator, and they wanted to publish the video to the jury. But the trial court denied the city's motion because the witness and surveillance, quote, comes way too late. So, I mean, there's nothing fair about that because the ruling that plaintiff was unavailable also came in the middle of trial. And we cited the published and unpublished Michigan cases that support admitting this kind of surveillance under these circumstances. I think the best case that supports our position is Garlic versus Great Lakes Steel Corp. It's cited in our brief, and it's unpublished, but it cites the published case law. So the court rejected the plaintiff's claim of surprise and prejudice, and the facts were the same. The trial court allowed the admission of the surveillance. Well, in that case, it did allow it, but it was not disclosed before trial, and it was not admitted until after the close of plaintiff's proofs, which would have been the same here. And the court said it was the plaintiff's testimony that made the videotape relevant as rebuttal evidence. And so while the plaintiff's counsel may have been surprised by the videotape evidence, the plaintiff knew what her capabilities were. So what made it relevant here, obviously, was this finding of unavailability. And then we also had the testimony from the conservator and the guardian ad litem report. It all made it relevant because it made the plaintiff seem like he was mentally incapable of coming to the courtroom and engaging in any activities of life. So again, this is just a textbook case of unfairness, and the city should be entitled to a new trial on that alone. I did also want to mention the witness intimidation issue because that's relevant to a new trial and also to remittitor if you get to that. So this would be Dr. Schutte, who is the Veterans Administration neuropsychologist, and he had initially treated the plaintiff. He could have provided a foundation for admitting one of the statements from plaintiff, that plaintiff actually went toward the moving tire and tried to stop it. And that would have been relevant to the jury's finding of fault and to proximate cause. And he also could have testified regarding that initial treatment. The gist of it is that Dr. Schutte had permission from the VA to testify as a fact witness, but plaintiff's counsel threatened him and then went ahead and revoked authorization for his testimony. So, it's in the record, so I know you don't need me to read it to you, but he testified under oath that he consulted 2 different Veterans Administration attorneys. Both said he was free to testify if he chose to. He just couldn't talk about substance abuse issues or HIV. The federal regulation that plaintiff and the trial court relied on specifically had to do with expert and opinion testimony, not fact witnesses. And again, I know you don't want me to read what he said, but if you look at his testimony, he's looking at plaintiff's counsel and he says, you have a very threatening posture. He says it like 3 times. You're taking a threatening posture. You made this threat to me. And so eventually plaintiff's counsel sort of interjects and says, well, I'm zealously advocating for my client. And then he revoked the authorization for his testimony. So aside from intimidating and threatening the witness, case should have been dismissed under MCR 2.314B2 because he revoked the medical privilege to impede discovery, and he was only seeking non-economic damages. So, the bottom line of this case is the court precluded critical evidence that would have helped the city in its defense, and it let the plaintiff get away with completely inappropriate behavior. So at the very least, the city is entitled to a new trial. And I can rest on the brief for the attorney fee issues, just address it in rebuttal if I need to. Any questions?
No, thank you.
Thank you very much.
Thank you so much.
Marco?
Good morning, Your Honors. May it please the court, John Marco on behalf of the estate of Bruce Wood. Judge Lucia, I'll start with your question. There was competing Daubert motions in this case. We had filed a motion to strike their expert, Dr. Eck, as unreliable under 702. They filed a motion to strike our expert. The court held a robust hearing on those motions, including reviewing supporting documentation and exhibits, ruled that the arguments go to the weight and that the jury would have to sort out the competing views of the competing experts, which we assert in our brief was not an abuse of discretion because it's an abuse of discretion standard.
Did the court have a hearing on your motions for a Daubert hearing, or did it have a Daubert hearing?
It was hearing on plaintiff and defendant's cross motions to strike.
Okay.
So they didn't call the experts in and put them on a stand in a Daubert hearing, but the court performed a gatekeeping function under 702, which is what they're required to do, on requests to strike each other's experts. We requested to strike Dr. Eck, their defense expert, defense requested to strike Mr. Robbins. We all had supporting documentation on those. The court considered all those, had a hearing, allowed us to argue, and I don't recall whether a specific request for Daubert was made in addition to that hearing. I'd have to refer to the transcript. I just know that the court fulfilled the gatekeeping function, considered the issue. There's a transcript of it. There's motions and there's supporting documentation for all of that, Your Honor. So I can address, I'll address what defense counsel addressed. For how much time do I have? Given it's consolidated appeal.
You get 30
minutes. Okay. So let me start with evidence of negligence. So this case's fourth trip before this court. There was Wood 1, Wood 2, Wood 3. I guess this is Wood 4. Previously, Wood 1 said that there was a question of fact for the jury on the claims. Wood 2 said there was a question of fact. Wood 3 said there was a question of fact for the jury. There was a lot that went into the soup of why there's a question of fact. It's not just Mr. Robbins' testimony, although we think it's important and we think it was helpful for the jury, but there was a lot of evidence. So first of all, perhaps most importantly, as you can see on page 11 of my brief, there is pictures of the tire that came barreling off this vehicle and started bouncing down the road at a high rate of speed. This tire was going over 25 miles an hour and it was actually bounding. It was not rolling. It was actually bounding, according to witnesses, up and down at a high rate of speed. There was chafing marks on the tire on the inside from actually the tire rotating so much and hitting the van. The van had only made it about 2 blocks. This wasn't a case where this van was in use on a highway. They're doing a long speed trip. This was Mr. Pennington, the driver, had made it about 2 blocks from the station and then the wheel popped right off. The wheel popped off, we know, because the bolts were not on it. So this is an exemplar that was introduced at trial. There's 8 of these bolts that hold the tire on. If you've ever changed a tire, like I have, I mean, when I was younger, that this bolt holds it on. The tire goes in between. It's like this. The tire cannot come off. And I know this might seem elementary, but the tire cannot come off.
I actually had one come off once, so I understand what you're talking about.
Well, something has to go wrong, right? So the bolt can break. In this case, it would require all 8 bolts to fail, which is statistically almost impossible. That all 8 bolts would break at the same time unless you're driving an old car that's so rusted out, which this car was. The bolts were intact, we know that, right? If these aren't placed on, or in this case, the city of Detroit mechanics testified that what they do, and remember, this was July 3rd. This was the evening before the 4th of July holiday. Everybody wants to get home. And they drove the vehicle close to closing time. What they do is they have air guns at the city. So it's not like the wrench that we use on our cars. They have this, and the mechanic places it on just like that. Doesn't touch it. They place 8 on, then they air gun it to put them all shut. In this case, their bolts were not on, or they were simply placed on and not tightened whatsoever.
But the jury found the mechanics not negligent, right?
No, they found them not. They found the single mechanic that was left not grossly negligent. So they said that she was not grossly negligent in this case, and that Mr. Pennington was simply negligent under the motor vehicle exception. Mr. Pennington, the driver, said he did not do a pre-trip inspection. He's required to do a pre-trip inspection. It's policy, it's standard in practice, it's safety when you're driving a commercial vehicle. He testified in his deposition he did not do it. He got on the stand. He told the jury he did do it. He was impeached. He recanted his testimony in front of the jury and said, I don't know why I said that. It's not true. So Mr. Pennington was an uncredible witness, but then he changed his story. He said, I admit I did not do a pre-trip inspection as I was required to do. That's evidence aside from Robbins. It's undisputed the tire cannot come off if the bolts are intact. The bolts were not sheared. It only made it a few blocks. He was going at a high rate of speed because the tire was going over 25 miles an hour when it hit Mr. Wood, and it was bouncing. And Detroit has offered no alternative theory. This is not a case where there was competing theories of causation, where the city said, here's what we think happened. Here's proof of this, more likely than not. The city of Detroit's defense was, we just don't know. Tires just come off. There's no reason. We can't explain it. We have no evidence to support our theory. And finally, in Wood 1, this court cited MCL 257.683 subpar 1, which is unsafe vehicle, which the court said there's evidence and this is law of the case now, that there's evidence that statute was violated, which would provide evidence of negligence. That combined with Robbins and the spoliation issues. The spoliation issues in this case are very important. I've never seen such a case for spoliation in my career. This court has already discussed spoliation in the previous Wood matters. I want the court to understand exactly what was spoliated here because it was a lot. So first of all, so Mr. Wood gets hit by this tire on July 3rd, 2015. He's in the hospital with 4 brain bleeds, a fractured back, a broken skull. He's deaf in one ear. The paramedic testified that she came to the scene and there was cerebral fluid from his brain that was actually coming out of his ears and was found on the pavement where he was. All right. While Mr. Wood is in the hospital at Henry Ford, this happened right down West Grand Boulevard here in Rosa Parks while he was walking to CVS to get cat food. While he was in the hospital on July 4th, the city of Detroit purged the electronic maintenance records for this van. Now, they have electronic records because they need to know when they need to change the oil, when they need to change the tires, etc. They literally purged them. They never offered an excuse for why they purged the electronic maintenance records. The head of the maintenance department was on the stand and he testified, I don't know why they did that. He then testified that there's a backup. There's physical maintenance records for the van that are kept in a locked cabinet inside the supervisor's office. He said that when this case was filed, he went and looked for those records and someone had removed those records for this van, showing the maintenance and the condition of the van at the time that it was taken out of the shop. He says, I can't explain why. Somebody had to go in there. I said, who could have done that? It's in the transcript. He testified somebody very high up would have had to go in there and take those records out. The city of Detroit has never offered an explanation for where those records are. Then we have the mechanics journal. Miss Denise Alexander Williams, in discovery, we asked for it. We found out that there was a journal that showed the condition of the van at the time that it left the Detroit station and drove 2 blocks. Miss Alexander Williams kept a little handwritten journal like you have in high school with numbered pages that has every single thing she would do, including to this van. She was responsible for this van. She testified that she gave the journal to the city of Detroit with all pages intact. When it arrived at plaintiff's counsel office after an order from the court, pages 82 to 85 had been ripped out of the journal. And we know that because it went from page 81 to page 86. If you look at the numerals in the actual journal, this was in evidence. We asked her why and how that could happen. She testified she doesn't know, that the pages were in it when it was given to the city of Detroit. So the evidence in this case has to be looked against this backdrop of spoliation. And then they also destroyed the tires, the lug nuts in the van. So when we hear there was not testing done on the van was destroyed or absconded with. We don't know. They never told us where the van was, even though we asked for it. The maintenance records were destroyed, all 3, a journal, an electronic database, the date after the accident, and records in a locked cabinet. So we asked for spoliation. This court had previously said that a spoliation instruction would be appropriate under the circumstances, and the trial court followed that order, which is consistent with the law on this. And by the way, if there's a notice, I didn't really see that they ever argued that we didn't know about this. The city of Detroit sent out an investigator on July 3rd. who took those pictures. Those pictures of the tire that we showed with the chafing marks, that's from the City of Detroit investigator. The investigation file was entered into evidence. In the investigation file, it said that the entire investigation of this incident was given to the City of Detroit Law Department. There was law department paperwork inside the investigation file. So the City of Detroit knew on July 3rd, 2015, the date of this incident, what had occurred. I'll address Robbins very quickly. Robbins, sister counsel said that his only experience was when he was a kid driving some truck. That's not true. Robbins is a former Michigan State Police trooper. He's a crash reconstructionist. He's a current, at the time he testified, and today, deputy sheriff for Aranac County. He's performed over 3,000 accident reconstructions. He has automotive and mechanical experience, formal education through Delta College, where he went to mechanic school classes. He also has real world experience in cars. Now they want to use that against him, that he has real world experience, but that is beneficial, not detracting from his qualifications. He's also a licensed paramedic who continues to drive an ambulance and treat patients. Based on his experience, training, and knowledge, he was certainly qualified in this case. The Michigan Supreme Court has recently come down on a similar case, Danhoff versus Fahim. That's D-A-N-H-O-F-F. Fahim is F-A-H-I-M, where the court said that scientific literature is not required, as this court and our Supreme Court has said many times. As we have said before, each case will present unique circumstances for a trial court to determine whether the expert's opinion is reliable. That's what the court did in this case. We thought their expert was unreliable. The court declined to strike their expert, Dr. Eck, and the jury both experts were cross-examined vigorously, and the jury was free to come to their conclusions in this case. With regard to the unavailability issue that we heard about, I think it's very important to understand, first of all, this is a procedurally improper argument that they waive. We had a joint final pretrial conference in this case where the judge required the parties to confer and list any objections as to exhibits and witnesses. During that pretrial conference, the city was informed and told that due to Mr. Wood's continuing deteriorating condition, including post-traumatic epileptic seizures, where he was hospitalized at Henry Ford for, he was seizing in his home, falling, and the police and paramedics found him with broken bones on the ground. This was in evidence. This was in the medical records, that he was more likely than not going to be able to testify at trial. The city said, that's no problem. We will read his deposition. And that was what was on the joint final pretrial from the city. They knew well in advance of this trial that he was unavailable. That was not our preference, as we had to read Mr. Wood's deposition where he was cross-examined the entire time. So I wasn't able to ask any questions. All the questions from Mr. Wood's under oath testimony at trial came from a cross-examination from the defense counsel. The trial court did not abuse its discretion under MRE 804A4 to find him unavailable. That was supported by ample evidence. There was a guardian, he was appointed a special conservator and then subsequently a guardian. After he was found, he was getting evicted from his apartment because he couldn't understand and pay bills. They found his dead cat that he wasn't able to bury in his freezer. His dead cat was found in his freezer because he wanted to be close to it.
When was the conservator appointed?
The special conservator was appointed prior to trial.
How much?
It was shortly before
That's
trial.
what I thought.
Yeah, it was shortly before trial. And to be candid, this case had been on ice for so long. I didn't get involved until a month before trial on this case. And looking back, I think both sides, plaintiff and defense, could have done a better job of buttoning up certain things in this case. But when this case was on appeal and nobody had really touched the case because it had been on appeal for so long, Mr. Wood's situation continued to deteriorate, including being hospitalized at Henry Ford, including starting to get evicted, including the police having to do welfare checks on him. He's a man who is a veteran of the Vietnam War, who testified and believed that he was part of SEAL Team 6, who went and captured Osama bin Laden with Obama and was awarded by the Prince of Kuwait an award for his bravery and things. He believed it. And and this is what he had: a skull fracture with 4 brain bleeds, massive brain bleeds, as you can see from the MRI images, which were admitted into evidence and testified by a treating neurosurgeon, Dr. Tej Paul Panu, that a large portion of his brain had actually been liquefied and damaged and died, and then filled with cerebral fluid. The cerebral fluid that was left, because as you recall, the paramedic testified that it was coming out of his ears. We had the VA, we had Dr. Seawicks, we had Dr. Panu, we had the conservator appointment, we had the GAL, who we had nothing to do with. I don't know the GAL. That was a court-appointed neutral GAL who said that he was not available. Defendant offered at one point on, this is Appendix 680, to say, we don't need him to come. We can just have him testify by his deposition. Then everything changed in the middle of trial.
By his deposition, though, they were going to, was it going to be a Zoom type of thing? He could testify from home during the trial?
No, Judge O'Brien, by reading his previously taken deposition, his discovery deposition, that was previously taken in the case.
And you're saying the defendants agreed to this?
Yes, they agreed both before trial commenced through the joint final pretrial order, which this was no surprise. I mean, there's no way he can come. A conservator's been appointed. He has a guardianship petition pending. The doctors say that he can't do it. And so they said in the joint final pretrial, fine, we're going to read his DEP, read his discovery DEP. That's A662. And if you look at the joint final pretrial, that's what happened. Then on A680, Ms. Grimaldi, who was the city attorney, testified that she offered not to have him come and to just read the deposition, which is consistent with what they said before. Then as the trial progresses and things start unfolding, they suddenly want to call Mr. Wood. And we had to address this with the judge, and the judge exercised her discretion. Remember, it's abuse of discretion. You may say, well, I might have done something differently. She was in the best position to address this, and she said he's unavailable. Plus, the prejudice goes more to the plaintiff than the defendant. They got to read the deposition was read that was a pure cross-examination by defense counsel. Let me deal with this, Dr. Schutte, because I've never been told I intimidated a witness. Dr. Schutte's been around a long time. I don't think he was very intimidated. You can watch the video if you want to see what actually happened. It's a whole 3 minutes. I thought I was pretty polite given the circumstances. But here's what happened with Dr. Schutte. So we wanted all the VA, the Veterans Administration doctors, to come and testify. And we had sent out subpoenas, Wayne County subpoenas through the state court to several VA doctors. And we asked them to come to trial. We were contacted by the federal government, by the Veterans Administration, who said, no, the state subpoena is not binding on us. They referred us to the Code of Federal Regulations, which I had never read before and never known existed, which is 38 CFR 14.800. This is on page 42 of my brief. And they referred us to this Code of Federal Regulations that says that VA personnel shall not provide opinion or expert testimony in any legal proceedings. And then it says the only exception is if the responsible VA official, which my understanding was out of Washington, D.C., because that's who we were contacted by, has to, in writing, which is the key, this is on page 43, grant special authorization for VA personnel to appear and testify. We wanted all these VA doctors to testify, so we had requested the attorney who had contacted us to allow them to testify. They said no. We're in the middle of trial. They noticed Dr. Schutte, a VA doctor, trial deposition within 24 hours without any advance notice. So the noticing of Dr. Schutte was entirely improper. We never received proper notice. It was 24 hours before his deposition. I appear at the deposition and I objected to the deposition under the circumstances. Mr. Patricus began writing a brief on this because we only had 24 hours and to write a brief to file with the court to strike his testimony. And I said to the doctor, I cited him the federal regulations, and he said, well, I talked to some unidentified attorney and they told me it was okay. He didn't identify who that attorney was. It's hearsay. We don't know who it was. and it doesn't comply with the federal regulation. The federal regulation says that the responsible VA official has to, in writing, grant special authorization for the VA personnel to testify. I objected. I said, we were told by the VA counsel from Washington, D.C., that you had to comply with this code of federal regulations. If it applies to us, it's going to apply to you. That's what happened. So number one, it was untimely. Number two, they didn't follow the rule. There's no Michigan case that we could find, but there's all kinds of other jurisdictions applying these codes of federal regulations. They admit they didn't follow the regulation. They admit they don't have in writing authorization. And then the third point is it's completely harmless. Dr. Schutte did a one-time 40-minute meeting with Mr. Wood years ago. He testified under oath that he does not remember Mr. Wood, that he can offer no testimony about any visits with Mr. Wood, that he has no recollection of Mr. Wood. He testifies specifically, quote, I have no position in this. I've been exceedingly clear. I don't even remember the gentleman. And I've been exceedingly clear. I don't recall. This happened quite some time ago. The problem that they have is that the trial court on the medical record said, you cannot, under Merrill versus Boderoff, which is the Michigan Supreme Court opinion, you cannot just include every hearsay statement in a medical record unless you satisfy another hearsay exception. She said, I'm giving you the opportunity to call people or to present evidence that can satisfy that hearsay exception. They never did. They never did. Dr. Schutte didn't cut it because he does no personal knowledge. He says, I don't remember anything. That's my record. I don't remember anything about it.
Can we go back and talk about, I appreciate this additional context about the VA doctor, but can we go back to talk about Robbins really quickly?
Yes, Judge.
So you talked about his training at Delta College, his background, his experience, and conceded that it wasn't actually a robust Daubert hearing that took place, but rather a hearing on a motion. What were the reliable principles and methods that, like, let's say we agree with you and we don't question that Robbins has a wealth of experience. What are the reliable principles and methods and application thereof?
Yeah, I think you need to look at his experience, training, and knowledge, which is exactly what the trial court did and exactly what Mr. Robbins has in doing over 3,000 accident reconstructions, which his training.
Maybe this is my lack of experience, but bear with me. Why does being an accident reconstructionist per se give you knowledge of a tire coming off?
Yeah, so his entire job and currently and for the Michigan State Police and doing over 3,000 of these is to go to accident scenes and act as an investigator like CSI to put together what happened, what's the positioning, how did it happen?
Yeah, but how many of those are like tires falling off?
He testified that he's had situations regarding tires coming off. I don't recall the exact number, but he had the training to do it. He had both mechanic training and he had training through the academy and on the force, on the Michigan State Police and on the sheriff.
Driving an oil truck and it explodes.
Mm-hmm.
You can see how if you want to do an accident reconstruction, that's sort of a niche area because you're driving with explosives and they explode. This isn't that. I'm not saying that, but it is a little bit unique. It's not cars crashing together. It's a tire falling off. And I'm not doubting that he has a wealth of knowledge and experience. I am questioning how it's applicable.
Yeah, I think if you read his testimony, I mean, I read his testimony again last night, and you read his testimony, most of his testimony is explaining general things about the workings of the tire. He used the exemplar. He explained how there's eight bolts that hold the tire in. He explained the mechanics of how this goes into here. He explained how there was no shearing of the bolts. He explained how he explained the tire markings on the inside. These are all things within his realm. He didn't stray far from his realm. This was not a case, for example, where a bolt had a stress fracture or the car blew up What's that?
The pictures were clear enough that he could testify as to the bolts. I know the
Absolutely.
pictures were clear enough that he could testify as to the chafing, but for example, how did he know that a sound would have been made?
He testified that based on his training and experience, that there would have been warning signs to the driver, including but not limited to sounds being made when that tire was violently hitting the side.
Training and experience how? Because you're saying his job for decades was to go to an accident after it's happened. So how does that lend itself to knowing that before an accident happens, you're going to hear sounds in this unique circumstance of an accident involving a tire coming off?
In his 3,000 plus accident reconstructions, each case is extremely different. Sometimes it's inclement weather that he has to
That gets at his experience, like
Yeah.
for this case. I'm not saying he's not experienced, but that's exactly what I'm getting at. They're all different, and I'm not convinced right now that any of it lended itself to testifying in this circumstance.
I think that we're splitting hairs by focusing merely on one small portion of his testimony, which is the sound. We provided a wealth of evidence, including the chafing marks on the inside of the tire, which were clearly from friction and rubbing against the tire when the tire began wobbling and coming off, which he had personal experience with, which he testified to. He had been to mechanic school. I mean, what type of expert would specifically we be required to have under this circumstance? The accident reconstructionist is the guy. I mean, this was not a metallurgy case, right? This isn't an explosion case. This is his specialty. That this wasn't a tire defect case where the tread came off and we're trying to sue Goodyear and explain how the designer manufacturing the tire. This is what accident reconstructionists do. This was the professional field. But he's an accident reconstructionist plus. He has specific mechanic experience, both practical in real life, doing it since he was a kid, doing a lot of it, and formal training through Delta College. Now, they can attack his credibility, I guess, and attack the weight of his evidence, but the judge was surely within her discretion. It's an abuse of discretion to say, I'm going to allow him to testify in the field of accident reconstruction on what he found. There was no dispute that the tire came off, at a high speed, that the tire hit Mr. Wood. There was no dispute about that. The police officer, the paramedic, everybody at the scene admitted it. They documented the location. The investigator from the city of Detroit came and took pictures. And Detroit never offered an alternative theory. This was such a minor part of the grand scheme of the case.
Let's get at that. So let's say I can't figure out how Robbins survived 702. And I think it was a mistake that the trial court made. How important was he to the outcome at trial?
Not important, other than to say, in terms of common sense, we could have litigated this case and won without Robbins. Now, as a experienced practitioner, that's not something that I want to have to do. I would like they had an expert, and then they could say, well, plaintiff didn't have an expert in this case. The only expert that you heard was our guy. But between the testimony of the police officer who was there, the investigator, the paramedic, the entire investigation file, the driver's own admissions under oath that he did not do an inspection, that the tire came off, that the physical evidence of the chafing marks on the inside of the tire showing where it contacted the van. This was not a case that required expert testimony. Expert testimony, I think, was helpful to the jury. It was helpful to explain, he could look at the tire and explain 8 bolts and how the tire is physically affixed to the vehicle. And some people don't know. I mean, a lot of younger people are on the way. He's never changed the tire. That to me is crazy. But okay, see? So, but that's helpful, I think, for me. And I think a lot of the jurors, they knew and they thought this was stupid, but we could have succeeded on summary and a JNOV, when you view the facts in the light most favorable to the plaintiff, when you look at the dearth of evidence plus the spoliation of all the records. I mean, we can't get beyond that spoliation. That was very important in this case. And it wasn't just one category. It was everything. Imagine trying to litigate a case. And by the way, the reason this caption has about 20 people on it is because the city of Detroit early on in this litigation took the position that we're not going to tell you who worked on this vehicle. They said, we're not going to tell you. Motions were filed. Detroit said, we're not going to tell you who worked on this vehicle. Here's a list of every single mechanic who is in that garage. All these people that are on the caption is every single mechanic that was in that garage. That's not our fault. That's because the city of Detroit refused. It's not sister council, but it was the law department refused to identify who worked on the vehicle. Then when the records come out, I mean, this is preposterous. This court recognized that in the previous Wood. They deleted the electronic records of a city commercial vehicle the day after the incident. They purged it from the records. That's an intentional action. Somebody went into cabinets, a locked cabinet that was in a locked supervisor office. This is not me saying this. This is the head, the defendant. This is defendant Luckett who testified. Somebody deleted those physical files. You have the mechanic. Somebody ripped pages out of my journal that would have shown exactly what was done. And then we're being criticized and we're being attacked saying, well, your expert didn't have enough information. Well, you deleted it.
Marco, just so you know, you're right about it. You're 30 minutes, so you might want to stumble.
Yeah. I'm happy to, there's a lot of briefing in this case. There's a lot of issues. I just point out most of the issues that are raised, if you look carefully at the record, were waived. They were not objected to, they were waived. And we addressed that in our brief. The second thing that's very important when you're taking a look at this is a lot of positions were taken and stipulated to, and then in the middle of trial, the city of Detroit tried to change their position on those issues. And finally, I just would remind this court, as it knows well, it's not what this court would have done. It's not what you would have done, Judge Young, if you were sitting there and examining whether Mr. Robbins could testify into this case. It wasn't an abuse of discretion. Was it so far afield? And if you look at Robbins' testimony in totality, because it seems that concerns you, very small amount of the testimony involved anything mechanical in terms of like noises. Most of it was certainly general accident reconstruction. And as somebody who's done it as long as him, if you look at his qualifications, he's done it many times before. He continues to do it, not just in lawsuits, but for the state of Michigan and the cities who trust him to do that. So I'm happy to answer any other questions that you may have.
Thank you very much. All right, rebuttal. I believe you used about 10 minutes in your opening argument, so just to guide you.
Well, I'm sure you don't want to hear me talk for 20 more minutes, so I'm just going to address just two things. One was, I don't know the date of the final pretrial order. It should be in the record, but I do know that on May 24th, the city did file a motion to exclude the deposition. So I don't think that they were in favor of that. They wanted plaintiff to be there. And then I do have to defend the city on the whole spoiled evidence issue. I think the point was, if the maintenance records had been destroyed, maybe that would have said something about the city, but it really didn't have anything to do with all the maintenance workers, but they're not even part of this appeal. So then the only way the city can be held liable is if the driver was negligent. So that doesn't have anything to do with a missing tire, but in any event, plaintiff never requested the tire until well after discovery closed. And there was no evidence that was intentionally destroyed. And then they, like you pointed out, there were the photographs, and their expert said that he could formulate his opinions based on the photographs. So that's all I would say.
Do we know if there was a hubcap on this tire that would have covered the lug nuts? In terms of Mr. Pennington's inspection.
I believe that was the testimony. It should have been in the photographs, but I know at least our expert testified that the wheel assembly it covered. So no, he wouldn't have seen them when he got in the van. So that would have been the only way you, and he testified that he didn't see. So that would be the evidence, and there wasn't anything to contradict that.
And what's your response to Mr. Marco saying, even if Robin's testimony was improperly admitted, it didn't, there was a bunch of other stops, so it didn't really make a difference in the outcome?
Well, the issue comes down to, did the driver hear something or feel something when he was driving? Because again, the evidence shows that the wheel assembly covered the bolts, so he wouldn't have seen that. So his testimony was, I didn't hear anything, I didn't feel anything. So there's nothing to contradict that if we don't have Robin's expert opinion. That's not an expert opinion. It was just the one time I was driving my 2005 Chevy Tahoe police vehicle, this allegedly happened to me, but that's not an expert opinion that can be used to contradict the eyewitness. Thank you so much.
Thank you both. Case will be submitted. Cases. Brings us to item number 11, 4 consolidated cases, 366821 OI Holdings versus City of Menominee, 366824 Rocky North versus City of Menominee, 366828 NU Group or New Group versus City of Menominee, and 366903, again, OI Holdings versus City of Menominee. We got some notice that at least one of these might be going away, might be settling. So and I don't know if that's true for all of them or if it's even true for that one. So maybe you can start out with what's the status of this appeal?
Morning, Your Honor. Steve Van Stepper for OI Holdings. With respect to your question about the status, this is a little bit complicated. I'll be honest with you. So we had a resolution with the city of Menominee. There was, some of the folks entered into a resolution.
Is this for covering all of the cases or just your case?
Well, I can speak to my client.
Okay.
Right.
Yeah.
And so there was a resolution, and there was a new ordinance that was actually enacted. As soon as the new ordinance was enacted, however, it was subject to litigation. So some individuals who had previously had licenses, in this case, sued about that ordinance to try to invalidate it. That litigation, the trial court resolved it, but it is now pending on appeal. So that is now subject to appeal. If that appeal is resolved in my client's favor, then this appeal probably is moot, right? I think I have to acknowledge that. The problem, of course, is that we're in a situation where we can't exactly let go of this appeal, because if the subsequent appeal doesn't go in our favor, then we would be back under this regime, we think, and we'd be stuck if we had dismissed our appeal. So that's where we are. And I acknowledge, it is what it is. Again, Your Honor, that's the current status. The current status is that there have been attempts at resolution. Those are in pending litigation, or at least pending appeal. And we're sort of hoping for a final resolution of that appeal, which would then potentially take care of this one.
So what's the status of that appeal in terms of the process? Is it just filed or is it ready for argument?
We're waiting for reply briefs. Yeah, so we filed our response brief, and I believe there are reply briefs that are due in several weeks.
So it'll be some time, presumably, before there's actually scheduled for argument and decision.
Depending on the court schedule, yes. Yes. Happy to address that further if you would like.
And you said you're speaking just to OI Holdings, but do you know if Rocky North and New Group also benefited from the new ordinance? Presumably that's like public information, right?
Yeah, I believe they did. Yeah.
Okay.
Yeah. I believe there was a collective deal. Yes.
So you are the only one I see sitting at appellant's counsel table. Are
Correct.
the others here for the other plaintiffs?
My understanding is that 2 of the appeals have been withdrawn for Attitude Wellness and then for Rocky North. And I believe that New Group, I don't believe that they preserved oral arguments. So I don't believe that they're here.
You're right. They did not.
Yes.
Okay.
So I'm happy to argue the merits and go forward on that basis, understanding, of course, the procedural part of this. On the merits, I guess I just start with the Open Meetings Act claim because Pine Brook Warren, right, that's the Michigan Supreme Court case. That has really resolved a lot of the unclarity over that issue. The ordinance here is very similar to the ordinance that was at issue in Pine Brook Warren. And of course, Pine Brook Warren, the Supreme Court said, you look not only at the ordinance, the language of the ordinance itself, but you also look at kind of the facts, how it was operationalized, how it was actually implemented. And the question, of course, is who was the quote de facto selector of the winners of the licenses. And in Pine Brook Warren, this is on page 464, the really critical part of it was that there was a committee there that ranked the applications. They went through a rubric and they scored them and they ranked them. And then they presented that recommendation to City Council, and City Council approved that without looking at the merits, right? They didn't go back and look at the underlying scores or anything like that. And under that scenario, the Supreme Court said, look, the de facto selector was the selection committee, and that means that the selection committee was subject to the Open Meetings Act, and because that was all in closed doors, there was an OMA violation. It's exactly the same scenario here, right? Again, we have the ordinance. The language of the ordinance says, there's supposed to be scoring done by the selection committee, which then pushes it to the JLPL committee, which then makes a recommendation to City Council, and City Council makes the decision. But we have, of course, testimony in the record from many members of council saying, look, we didn't look at the underlying applications. We essentially just took the recommendation and went with it. And it's
Does
a little
it
bit
matter, like, is the OMA violation unique to this case because the JLPL had the tie and didn't really opine on anything? Do you think that middleman, because that's different than Pine Brook Warren, right? Pine Brook Warren is more like Menominee's selection committee directly to City Council, no middle JLPL committee.
Right.
Does that middleman, if it had worked functionally and they hadn't tied and they had written something to the City Council, does that make a difference?
I don't think so.
Okay.
Right. I mean, so the question is who, again, on a Pine Brook Warren, who is the de facto selector, right? And they could have been, the selection committee. It could have been the JLPL committee. Could have been Mr. Botbile because he testified that, hey, I took the ranked scores and then I considered by myself what was in the best interest of the city and then presented that recommendation to the City Council, right? So he very well could have been the person who was the de facto selector. Any of those groups who makes the decision, who makes the de facto selection, they are subject to the OMA, right? So even a one-person selection committee, right? If Mr. Botbill, kind of operated as a one-man selection committee, that's just exactly like the Booth case, right? Where you had the U of M regents who kind of said, look, we're going to have one regent make the decision, winnow all the applicants, and then present that to the board, and that would be, and then we just kind of rubber stamp that decision. Same issue here.
Yeah, let me talk to you about the rubber stamping. So we know in fact that the one that Botbile and the selection recommended were the ones who got licenses. Is like, how important is that versus the fact that Botbile and selection committee are the only ones who see the applications? You know what I mean? Like, what if there was one difference? They gave one person license, but not the other person. Presumably the Open Meetings Act shouldn't depend on the exact adoption because they would still have the decision,
Right.
what I mean? Like, help me understand.
Yeah, no, and it's a little bit complicated by Pine Brook Warren, right? Because the Supreme Court says you don't just look at the ordinance, the structure, the legal structure. You have to actually look how it's operationalized, and that's going to make it depend on the facts to some extent, right? And so there may be some facts where you have a recommendation to the City Council, and the City Council says, we want somebody else, right? Then the City Council would be the one who's determining the public policy, in Pine Brook Warren's words, determining the public policy of who should get these licenses, right? Now, for our purposes in this case, who determined the public policy of getting the licenses, it's pretty clear it's Mr. Botbill. Maybe the selection committee, but pretty clear Mr. Botbill.
He was a member of.
Exactly,
Yeah.
right. Right. And then Mr. Botbill's recommendations went to the City Council, and then City Council members, many of them testified, look, the whole point was that we didn't have to get involved. City Council didn't have to get involved. We just kind of approved what we got from the committee, i.e. Mr. Botbill, without checking over without really second guessing it. So the public policy determination of who should get the licenses at the end of the day, it was Mr. Botville, the selection committee via Mr. Botville, not the
And
council.
another alternative hypo could be the minutes of the city council meeting, which I guess aren't really on the record, but let's pretend they were. If they showed a ton of deliberation and the same decision, then we'd probably be in a different boat too, right?
Maybe, yes. Again, it's hard to determine. I mean, the question is who was the de facto selector, right? If the record was different, if the facts were different, and it would turn out that city council actually was the one who made the decision, right? They went back and they had the applications available to them, and they looked at them, and they interrogated exactly who's the best fit, and they went into that with a lot of depth. Then the city may be in a better position because you may say, well, look, they had a recommendation, but they didn't really delegate the ultimate authority. They kept it for themselves, and they actually exercised that authority, right? Because that's the real problem, right? Under cases like Morrison and Booth, right? You've got the city who's essentially delegating the decision and then just saying, okay, you guys made a decision, sounds good to us, move on to the next business. That's the problem here.
And what do we do with the fact that 2 of the relevant meetings were public? Let me think about this. The city council meetings are always public. 2 of the selection committee meetings were public as well.
Well, so I think there were some public meetings, but the selection. So Mr. Botville's own kind of assertion was certainly not public, right?
Yeah.
And that seems to be where the final decision was made, because he didn't even accept the final scores of the rubrics, right? I mean, he didn't adopt with them because there were 2 that scored perfect, and he decided, well, I'll take one of those and somebody else who didn't score because I think somebody else has the best interest of the city. So clearly, his own analysis of his own decision about who really should get the licenses, that was not public. So I don't think the fact that maybe some of the some of the meetings were public, I don't think that changes the analysis here. Hopefully that answers the question.
Then you're really arguing that the decider is one person, right? You're not talking, it's not a committee.
Yep.
Because the committee held meetings where you were entitled to go in, and you did, I think, argue for why should be better scoring or more points or whatever, right?
Well, there was some back and forth, although I believe that, and I may be confusing cases, but I believe that in this instance, some of those meetings, the applicants were not allowed to participate. The city may correct me on that, but I believe that may have happened. But I mean, in terms of the one-man committee, right? That's the Herald case, right? Where essentially one person can't be a public body, but you can, the question is who has the authority to make the decision in the first place? So the ordinance says the city council has the authority to make this decision. That is a public body. And then the question is, okay, does that public body, did that delegate its authority? Did it say, okay, subcommittee, you go make that decision for us, come back to us with a recommendation and we'll rubber stamp it? If that subcommittee consists of one person, that's still it's subject to the Open Meeting Act, because the public body's authority has been delegated, even if it's being wielded by a single person. And that's the University of Michigan case, right? So it would be a different case if an ordinance said, look, city council isn't involved. A city manager, the one person, they have the ability, the discretion to determine all this. Well, one person isn't a public body. And so an ordinance that was structured that way would not make the city manager subject to the OMA. So that's the Herald case, where there was essentially, I think it was the city manager who was responsible for hiring a public safety chief, I believe. And the court said, well, he as an individual isn't a public body, and so he's not subject to the OMA. That's not the situation here, because the repository of the authority is clearly a public body. It's the city council, and then they're using a single person to kind of make the decision for them. So that's the distinction there. And again, I think that Heinberg Warren case really resolves most of this particular claim. So that's the Open Meetings Act. Well, let me just touch on the equal protection claim. So there was a motion to dismiss. It was a C8 motion. The question here on equal protection is whether we adequately pleaded an equal protection claim under state law. And this is about the Rudolph Steiner case. And of course, we took the position, well, the trial court said, look, under Rudolph Steiner, a plaintiff needs to allege and prove a deprivation of a property interest or a liberty interest. Of course, we took the position that that's inaccurate, particularly given state law that suggests that, or that holds that the state equal protection jurisprudence is coextensive with federal equal protection jurisprudence. I think that's pretty clear. And if nothing else, it would be wonderful if this court would clarify that going forward. The city says, look, there are some other reasons why we failed to plead a equal protection claim. They said that we didn't plead that it was an intentional act by the city. But I would point this court to pages 8, 9, and 10 of our appendix, which is where our complaint is. And there we allege that, among other things, the defendants, quote, blatantly ignored sections of plaintiff's application materials, and then also that the defendants gave preferential treatment to other applicants, right? That's all intentional conduct. And so I think we successfully pleaded intentionality. And then the city also has an argument that, look, this is a matter of discretion, and so that we don't really, you can't plead a complaint with respect to this. I would say number one, those cases are, summary judgment cases, C10 cases. This is, again, a C8 motion. The only question is, did we adequately plead something? And I think we pretty clearly did. And I would say, secondly, kind of more fundamentally, the city can't just evade the Constitution by saying, look, we're going to give ourselves the discretion to treat people arbitrarily and irrationally. That's not the way that the Equal Protection Clause works. So that's the equal protection part. And then finally, the MRTMA question, and this is the competitive process question. And again, I want to make clear, our argument is not that the criteria that were selected, that there's something wrong with those, that's anti-competitive. Because Yellowtail, right, that says, look, the municipality has broad leeway to pick whatever criteria they want, as long as it's reasonably related to the ultimate goals of MRTMA. Now, our argument is, well, it wasn't a competitive process as applied, as it was implemented. Because, well, number one, if the competitive process under the ordinance was the scoring rubric, right, where they had certain points for certain things, well, it turns out that Mr. Botbell didn't even follow the results of the scoring rubric. So the scoring rubric, if that's the competitive process, well, then clearly it wasn't complied with because Mr. Botbell didn't comply with it, right? He didn't follow the results. And then the other problem is, of course, that if Mr. Botbell's kind of subjective beliefs about what's in the best interest of the city, if that's the criteria, it's hard to see how that's competitive, because it's hard to know how an applicant could ever know what Mr. Botbell thought might be subjectively in the best interest of the city. So if you never know what it takes to score a goal, it's really hard to say that that's a competitive process. And in
It's not a better argument. There's a huge part of this process that is competitive, you conceded, which is the rubric. One of the two top scoring candidates got a license. The other one did not. But and to your point, because some of that process is not public, that's inexplicable. But I don't know that makes it non-competitive, because the rubric still exists, it still matters. They didn't pick the two bottom.
Well, I think so I agree with you. The transparency, I mean, this is a great case for why the Open Meeting Act should apply here, because transparency would have helped a lot of this. And it would have also helped another problem with the process, which was that there apparently was a bunch of ex parte communication, right? I mean, if I'm thinking about like an ordinary municipal bid process or RFP, there's no way that city actors could talk with some of the people submitting bids, right? And apparently that's what happened. We didn't know that until later, but apparently, some of the applicants were reaching out to the city manager or the former city manager, and they were saying, well, does this count as a new facility? And maybe not. And they were getting kind of advice about how to comply with certain interpretations of the rubric and given new interpretations of the rubric. And of course, our submission, I think we were one of the first applicants to submit. And we didn't have the ability to, we didn't know about these things. We didn't know that there was, number one, an ability to talk and appeal, to get advice about what these different things meant. In fact, we were told that we weren't allowed to, appeal, and we weren't allowed to reframe our application. And so to the transparency point, obviously the transparency point would have helped out a great deal. But it also makes it non-competitive, right? Because the rules are different. It turns out the rules were different for other applicants versus our applicant, versus our client. And again, it's hard to say that it's a truly competitive process when the rules are one thing for some applicants and something entirely different for another. Now, to the extent that there's an Open Meetings Act violation and the whole thing has to be redone, that may solve the problem going forward. But I also think that those errors made it not a truly competitive process as implemented this time around, if that makes sense. Unless there are further questions, I can save time for rebuttal.
Thank you very much.
Thank you.
Good afternoon.
I was going to say good morning, but good afternoon. May it please the court, Brianna Combs on behalf of the city defendants appellees.
Before you jump in, we have other counsel here. Can you tell me who all is arguing on your side of the aisle?
I will just be arguing on behalf of the city, and then I believe the other two gentlemen here will be the intervening defendants appellees.
So you
Yes.
know you have 30 minutes combined.
Yes,
right?
I will not
Okay.
take the whole time.
Okay, all right.
Give respect to them as well. First, I want to address your point, Judge Boonstra. It's the city's position that this appeal is moot. There was a settlement agreement that was entered into by all 5 plaintiffs. 2 of the plaintiffs have since filed motions to withdraw their appeals. I know one was filed yesterday, one was filed, and I believe this court entered an order back in October. This settlement agreement was signed by all 5 plaintiffs, signed on behalf of the city. It speaks directly to, it lists all the trial court case numbers in this case, and it speaks directly to this appeal. And we're happy to submit supplemental briefing on that issue if this court would like us to. I do apologize for just bringing it to the court's attention now.
We haven't seen what was filed yet.
Okay.
So you're representing that it was filed on behalf of all of the appellants or no?
Yes, it's signed by all 5 plaintiffs that are involved in this appeal and also on behalf of the city.
But to Judge Boonstra's point, that settlement agreement is not filed in our court.
Correct.
Okay.
So if this court would like supplemental briefing on that issue, we're happy to provide it.
Okay, so the motion that was filed or motions is, I don't know if there's one or more than one. Were they filed on behalf of all of the appellants?
No, I believe Attitude Wellness and then Rocky North filed their motion yesterday to withdraw the appeal. So that's 2 of the 5.
Okay.
Yes.
All right.
So it's our position, that's our position, but I can briefly address the merits as well, just to preserve our arguments, which I believe are well laid out in our brief, but I will address them briefly. First, regarding the Open Meetings Act, to answer your questions, which I believe you had for opposing counsel, there were 2 open meetings held by the selection committee. One was on August 24th of 2021. That's in our appendix at 000302. And then there was another open meeting on August 26th. And at that meeting, the applicants had the opportunity to address the committee regarding any concerns they had regarding the scoring. That's in our appendix at 000302. And also, I think important to this issue is testimony in the record from one of the council members who was present when the city council made their decision, Jacqueline Nutter. She testified that the city council did not just have the 2 recommendations from the city manager. They had, and it's in our appendix at 1058. It's a chart of all the scores of all the applicants. It's not ranked in any order. It just gives the scores, and it also has a column listing if there was any point deductions, why the selection committee deducted those points. So the city council certainly had the discretion to look at that scoring chart and make their own decision, which they did after seeing the chart of scores, which were not ranked. And I think that's what distinguishes this case from Pine Brook Warren, is in that case, not only was there recommendations made, but there was also a ranking of the applications, and that did not happen here. The city council had their own discretion to rank them how they wanted to. They did not have to, the ordinance did not provide that the city council had to rely just on the scores. They could have ranked them how they wanted to. They had the discretion and they made their decision. So I think this case is distinguishable from Pine Brook Warren. And then on the equal protection issue, Rudolph Steiner, the trial court correctly relied on that case. That involved an analysis of the Michigan Constitution. It's still good law. It has no negative treatment. And the trial court properly followed that as binding precedent. And then in terms of the federal constitution, we lay our arguments out very well in our brief about this class of one type of equal protection claim. It's a very high and heavy burden, as we cite in our brief, to meet this type of equal protection claim in a class of one situation. OI Holdings did not allege in its complaint that it was intentionally treated differently from others similar situated. Rather, it just grappled with how the scoring was done. And again, if you look at that chart that's in our appendix, which gives the rationale for all the deductions of the scoring, I think that definitely shows the rational basis here for the decision that was made in terms of equal protection. And then finally, going to the Michigan Regulation and Taxation of Marijuana Act claim and the competitive aspect of this appeal. As we cite in our brief, the Michigan Constitution gives municipalities great latitude to conduct their business. Again, the act here does not require perfection, even if the selection committee made errors in its scoring, which it did not, but those errors would not render the process non-competitive. I think Judge Young, as you were pointing out, and in our brief, I think we made a point that gets to what you were saying. The plaintiffs make an unfettered discretion argument, but that argument should be rejected. The city council did decide to award the 2 licenses to 2 of the top 3 scoring applicants. And then subsequent to that, another 3rd license was issued to Attitude Wellness, which was the other top scoring applicant. So we don't have a situation where the city was awarding these licenses to the 2 applicants with the lowest scores. By no means did that happen here. And there are several cases that support the city on this issue, which we cite in our brief, including the Yellowtail Ventures, Exclusive Capital Partners, and the Blue Water Cannabis case. And in that case, this court said the weight given to each factor by the selection committee and how the city council eventually arrived at its decisions are not the type of matters that should be judicially reviewed. So I think that's all that I have, unless this court has any questions.
I have a quick follow-up about the settlement agreement. Brother counsel argued that it was in some way dependent on the outcome of a separate appeal. Do you think that is true? Is there anything in the language to support that?
I'm not involved in the second appeal, so I'm not sure all the claims that are involved in that separate litigation. I did read through the settlement agreement several times, and it defines it just as any future appeals. So I think it would cover this litigation and that separate litigation as to how I read it. It seems pretty broad. So that would be my position. But again, I'm not involved in the second litigation, so I'm not sure.
Sorry, let me phrase that differently. Is it at all contingent upon the new version of the ordinance, the settlement agreement?
So,
because if the new version of the ordinance is overturned in some way.
Sorry, I'm just reviewing certain part of it. It speaks about the amendment of the ordinance, which did happen. And it speaks about if that amendment is done and if these plaintiffs are issued licenses, then the settlement agreement goes into effect. So, and to my understanding and speaking with the city, the ordinance was amended to allow for an unlimited amount of licenses. Subsequent to that, all the plaintiffs reapplied and then were issued licenses. And I even went on all the plaintiffs' websites yesterday, and they're all operating in the city as to what the websites and all the plaintiffs say. So that's the status.
Okay.
Thank you.
Your honors, may it please the court. My name is James Martone. I'm representing the appellee defendant, intervening defendant, the Fire Station LLC. Judge Young, just to clarify, that settlement agreement is not contingent upon any future appeals being dismissed. That settlement agreement was entered into in May of 2023, shortly after the first Menominee litigation was dismissed by Judge Barglin. Pursuant to that settlement agreement, all the plaintiffs were required to receive a license, and upon receiving a license and amendment of the ordinance, the first ordinance, they would dismiss their claims, release claims, dismiss any pending appeals or lawsuits. So it's intervening defendants or appellee, the fire station's position that that settlement agreement is in, or they're in breach of the settlement agreement by not dismissing this appeal. And so we would say, for these reasons, this appeal should be denied because there is already resolution of that pursuant to the settlement agreement, which as counsel had indicated, if the court would like us to file a motion to dismiss or supplemental briefing, we're happy to do that. Similarly, as sister counsel indicated, we do believe not only because of the settlement agreement that this case is moot, but we also believe because there have been subsequent amendments to the ordinance, the original ordinance under which the guidelines or the framework came about for this licensing process, that any arguments or any dispute over the licensing process is now moot, particularly given the fact that the ordinance was amended once in, I believe, July of 2024, or excuse me, July of 2023, and then again in August of 2023, which did uncap the licenses that are to be awarded.
Did it make all the meetings public?
Yes.
Okay.
There was a subsequent litigation that I was involved about the OMA claims about that, but Judge Barglin and the testimony that came out identified that there was no OMA violations. And so those subsequent ordinance passages were OMA compliant. And so for those reasons, and it's my understanding that there might be even a third ordinance amendment coming down the pipeline. And so for the court to issue a decision on this old ordinance could create substantial confusion on a go-forward basis, particularly given the fact that all the licensees, particularly my client and Rise, who received the license under the original ordinance, had already multiple occasions to re-up, if you will, for lack of a better term, each year with the city, which has taken place under the current ordinances. And so whatever complaints there are about the prior ordinance have been resolved because all these subsequent ordinances and the licenses that have been issued or reissued are through the current process. Nonetheless, I do want to just address briefly some of the topics that were discussed today, particularly Judge Young, you did ask about the OMA situation and whether or not you think this intermediary with the JLPL or how the Pine Brook case somewhat is applicable or is inapplicable. I think it's telling here because unlike the Pine Brook, and Judge Young, you hit on it properly. This wasn't the review committee met in secret, did all the scoring and rankings, and then said, hey, look, City Council, you got to accept 1, 2, and 3, which we ranked. And that's what was done in open meetings, but that was rubber stamped. Here was a much more deliberate, much more open, and a much more consistent process with what you would say the Harold case was. There were 2 open meetings in August of 2021. There was the original, and Judge Young, I believe you asked, were participants able to participate in the August 24 meeting? This selection committee identified this is the rankings. Come back on August 26th, and you have the opportunity, every applicant has the opportunity to appeal that ranking or make a last ditch effort, if you will, to the selection committee. I think you got it wrong on why you took points away. I should be awarded more. And that was done publicly. Then those scores were announced at the end of that meeting, identifying now who are the rank or what are the scores for each applicant. Again, there was no rankings by the selection committee. They didn't say, because you hit 50 points, you're number 1. Because you hit 48 points, you're number 2. They just said, these are the applicants. These are your scores. Those scores then were recommended to the JLPL. The JLPL, Mr. Botbile, the city manager at the time, said, I believe these ranked or these scored applicants should receive a license. And I want to make a distinction here. Unlike Pine Brook and unlike all the other cases, this wasn't where they took the top scorers. There was an independent evaluation too, which Mr. Botbile did identify in a public comment. I want Rise, who received a lower score than Loom, to receive the recreational license over Loom because of this issue with the special land use permit and whether or not that was obtained at the time or not. So this is not a situation where you have a selection committee in closed doors saying, these are the top 3 or top 2 that we're going to recommend, give it to the city council, and the city council rubber stamps it. This was a different situation. There was just a scoring. Then that scoring went to the JLPL. JLPL didn't make a recommendation. Mr. Botbile's recommendation, again, acting as the city manager in his individual capacity, not as the selection committee, makes the recommendation, or his recommendation gets forwarded to the city council. And the city council takes it up. And the sister council identified there was conversation. The council personnel had the notes, what was deducted, why was a 48 being recommended over a 50 scored, and there was robust conversation. And as this court knows, there's no standard, and Judge Young, I believe you asked, well, if there was hours-long conversation on the record, would that satisfy you? There's really no standard. It's just, these are the decisions that are being made. Does the council feel comfortable with it? And they can make that decision. Mr. Botbile didn't make that decision. The selection committee didn't make that decision. The JLPL committee did not make that decision. There was a recommendation based upon what they had reviewed and what was scored, but ultimately, which again, not only did it play out in practice, but also is identified in the
City council had robust discussion about this.
city council had, I was present there, and there was enough discussion on there that this was not just a rubber stamp. And I'll particularly recall, and I apologize for interjecting my personal experience, but there was concern over a 48 being issued a license over a 50. And particularly given the fact, well, why a 48 over 50? And the council individual and the council members did discuss that. That was sufficient. There's not, again, there's no time frame that you have to have on the open meetings. It can be 5 minutes, it can be 5 hours, but there just has to be open meetings on a subject, which there was. Prior to the recommendation, no licenses had been issued. No applicant was able to open up a retail store. They had to wait until the city council met. During that meeting, there was conversation about the scoring and about the reduction of points. And then ultimately they did go with Mr. Botbile's recommendation and awarded the license to the fire station, my client, and other intervening defendant appellee, Rise.
Agree with brother counsel that Mr. Botbile was made those recommendations solo. That wasn't part of his role in the selection committee.
That's my understanding, Your Honor. And so for that reason, Your Honor, I would commend to the court that this is more akin to the Herald case, where you can't have an individual be a public body without and have Mr. Botbile talk to himself. With respect to the equal protection claims, I'll, for sake of brevity, I'll adopt Sister Counsel's comments. I do believe that the Rudolph Steiner case is still valid law. That is the rule of law that the courts have to follow unless said otherwise by the Michigan Supreme Court or this court. I haven't seen case law saying otherwise. And so because there has not been a vested property interest by first-time applicants, there is no equal protection violation there. Similarly, for all the other reasons, we would confer for the other federal claims about equal protection, we would refer the court to our briefing and the other appellee's briefing on that matter. Lastly, with respect to the competitive process, I believe the Carey case and I believe it's the exclusive case that this court just recently issued that identifies competitive process doesn't have to be perfect. And I think even Judge Barglin summarized it or analogized it perfectly in her opinion that an NFL football game, regardless of how the referees call it, whether it's a bad call, a good call, or a missed call, that's still a competitive process. And that is the situation we have here. Plaintiffs in this case, they're not happy with the outcome of it. And they try and start saying, well, they should have done this, they should have done this. You missed that call. How come I didn't get these points scored? But that is akin to, you know, when the Lions are trying to, I forget who it was recently, but the knee was down on the 1 yard line, but they still ruled it a touchdown, said it was some sort of forward movement. That was a bad call. The plaintiffs can have that same argument all day they want, but at the end of the day, that is not what Carey or what the exclusive case has identified as the proper protocol on defining what a competitive process was. As long as there are guidelines, such as the rubric are, that identify who is best suited to operate within the jurisdictional limits, it is, as the Carey opinion identified, it is the city's call to make that determination. It is the city's call to make those rubrics. It's the city's call to score those rubrics and how they score those rubrics. So at the end of the day, it is not the judiciary to second guess how the city believes the operators are best suited to operate within their city limits. That is the city's. And so whether or not plaintiffs agree with it, whether or not defendants agree with it, at the end of the day, it is the discretion of the city to create that competitive process, which they did, which they followed, and under which they issued the 2 licenses to the fire station Rise. Unless the court has any other questions, I will sit down.
Thank you, Mr. Martone.
Thank you.
We have one more, I think.
Good afternoon, Your Honors. Nathan Sherbarth on behalf of intervening defendant Appley First Property Holdings, doing business as Rise. I will be brief. I don't know how much time is left, but I don't have much to say. I will adopt the arguments of brother and sister counsel as to the substantive issues. I did want to provide a little more context as to how this all developed, how the ordinances have changed and so forth. So the original ordinance that went into place in, I believe, 2021 allowed 2 recreational facilities and 2 medical facilities in Menominee. Under that process, the fire station, brother counsel's client, and Rise were awarded the recreational licenses. The disappointed bidders, including OI Holdings and these other appellants, filed their cases alleging these various claims. Those all eventually get dismissed. These cases all get up to this appeal. And then in the meantime, the city enters this settlement agreement in May of 2023 with those disappointed bidders. The ordinance is then changed in July of 2023. It goes from 2, there was a 3rd issued, but it goes from a limited number of recreational licenses to unlimited recreational licenses. All of the appellants were granted recreational licenses, and upon information, I believe they still have those licenses. Under the Cannabis Regulatory Agency website, you can, it's possible to take notice of the licensure status as to OI Holdings. They do have a current license number AU-R-1081. They have their recreational license. That's the whole reason they brought this case in the first place. They have the license. Since then, the city has again amended the ordinance to go from unlimited licenses to, in August of 2025, limiting it to 9 licenses through a special election. That special election result was undone because that ordinance change could not be done through a special election. It had to be done in a general election. And then that was put on the ballot in November of 2025, overwhelmingly passed to limit the number of facilities to 9. There are 9 facilities currently with recreational licenses, including OI, including New Group, the appellant that has did not preserve argument, but has not withdrawn its appeal or sought to dismiss it. And I just wanted to make note of the subsequent appeals. So once that ordinance was changed, Rise, the fire station, filed additional litigation when the ordinance was changed to allow unlimited facilities. There are now 3 pending appeals that are in the middle of briefing, as brother counsel stated. Docket numbers 373-084, 373-140, and 373-144. The settlement agreement should be accessible through 373-084. Event 60 is the appellant's brief. That's appellant Rise in that case. Attached as Exhibit A to Rise's complaint in the action from which that appeal stems was the settlement agreement from May of 2025 or 2023. I'm happy to answer any questions, but our position is this is all moot based on the settlement agreement and the fact that they have the licenses they wanted.
You were a party to the settlement agreement? No.
No, we were not a party to that agreement.
And you have since lost your license in the going down from unlimited to 9?
No, we still have our license. Everyone still has their license.
How many, city of Menominee, how many of these
say.
establishments can handle?
Candidly, your honors, think about the geographical location, proximity to Wisconsin.
Gotcha.
Unless the court has any questions that.
Thank you very much. Appreciate that additional information. Rebuttal?
Thank you, your honors. Excuse me. Just on the last point about the settlement agreements, all that kind of stuff. I would have expected a motion on any of this. If they think it's moot, they should file a motion that's moot so that we can actually respond to some of the allegations that they're saying. I don't have any, as I sit here, I think it's correct that there's a settlement agreement, absolutely, that there's been an ordinance, and apparently the ordinance has also been changed again. It was unlimited at some point, and it sounds like now it's limited again to 9. Which means that some of these very same issues, right, could crop up again, right? So you've got the, in terms of mootness, you've got the repetition capable of evading review. So that is something that we're happy to brief if we need to. But with respect to the settlement agreement, it was basically, okay, we'll take care of this appeal, these issues, if you change the ordinance. The city changed the ordinance, and then immediately the fire station and Rise, who are represented here, challenged that and said, no, you can't change the ordinance. It's illegal. Trying to revert it back to the situation that we have under this appeal, right? So we're in the situation where we thought we had resolved it, and suddenly we're subject to litigation again. And so we're in this very awkward position where we can't let this appeal, currently before the court, we can't really let this go because if the fire station and Rise are successful in their appeal, the second stage of appeals, we may be right back to where we started, which means, we can't let go of the appeal yet. So that's our position. Happy to brief it if there's a motion or if the court wants. Happy to address those things.
Make sure I understand that part. Your settlement came before the ordinance changed to unlimited. And then in August 25, it was unlawfully changed to go down to 9 licenses in a special election. November 25, the 9 licenses became official by way of general election. So presumably the August 25 undoing but special election was courtesy of Rise and fire station litigation.
I can't speak to that, Your Honor.
Okay. And then now there's present litigation about the November 25 ordinance.
I believe there's yes, I believe there's a third set of litigation with respect, and this is by somebody who wanted to have the 10th, who wanted to exceed that cap, and now they're challenging the cap itself. I believe that's where we're, and again, my understanding is that was recently filed, obviously November 25, and I believe they are waiting for an amendment.
Here's my question. If your settlement preceded the unlimited, and if the 9 proves problematic, you go back to the unlimited, how is this not moot?
Well, so there are 3 sets of cases, right? So there's our case, which is the first set, where we say we are challenging the limit to 2, right? And then there's a settlement agreement, and it expands it, and it limits, and you get uncapped, it's unlimited. That unlimited ordinance is challenged by the fire station and Rise. That is currently on appeal, and that's the one we're waiting for reply briefs on. So that's the second stage. And then there's another ordinance amendment, and that ordinance amendment says, okay, we're going to take that unlimited, and we're going to move it down to 9. And my understanding is apparently that happened in November. And my understanding is that there's a third batch of cases related to that third ordinance. And I believe that's correct.
Iteration 2, or if there's a problem with unlimited, it could hypothetically go back to 2.
Yeah, again, we're confident on our arguments, right? But we are concerned that if there's a problem with Amendment 2, that it could go back to just only having 2 licenses. Yes. That's the story there. The only other thing I want to say is on the Open Meeting Act, the OMA claim, right? The notion that city council, went through in great detail the various different rubrics. We pointed to this in our brief, the testimony from the various different council members. Councilmember Plumell at 560A of our our appendix said, look, the council basically stamp approval of what the committee recommended. His email, Mr. Councilmember Plamel's, his email is at appendix 826A. He reminds the other council members, hey, remember the idea, quote, was to keep council out of this. Mayor Stegeman testified that the council relied on the committee's recommendations. That's at appendix 784A. Councilman Steve Pfefferick, he testified that he didn't read the applications. He just went with a recommendation. That's at appendix 560A. Mr. Peterson, who was also a member of the committee, was asked, well, what's the deal with the rubric? And he said, quote, it's government, you jump through hoops. And that's at appendix 849A.
And how much of that can be considered? It was a C8 motion, wasn't it?
That's a initial procedural problem. Yes. And we mentioned on a brief, this is a C8 motion. At very minimum, this is a C10 question, right? And Heinrich Warren makes that very clear.
Right.
You look at not just the ordinance, you look at actually what happened. And so,
Because none of these emails were attached to the complaint.
right.
They all came later. Yeah.
They all come out.
Okay.
Yes. Yeah. So definitely on if there's a procedural hurdle right at the outset. If you get to the evidence is pretty clear. The city is not entitled to judgment as a matter of law. Unless there are any other questions.
Thank you. Thank you all. Appreciate your arguments. Those cases will be submitted. I guess I would say I'm not recommending anything, but if there are other motions to be filed, file them before we make a decision, and we can take it into consideration. All right, moving to item number 12, case number 371918, In re K.M. Alexander Minor. I believe we have one attorney endorsed, and I believe it will be remote. Good afternoon.
Good afternoon, Your Honors. My name is Maria Hobecki. I am representing the guardians in this matter. I'm happy to answer any questions that you may have. However, as there's no opposition in this matter, appellant will rest on our brief and help move the court along on its docket.
I appreciate that.
Is there any world in which the guardians would have to pay something of the LGAL? Or
No.
Ways the legal parents?
No, there is, I believe I've listed every court rule, every statute, every case, Michigan Supreme Court.
I just wonder if the guardians could be considered the person responsible for the support of the child.
No.
Okay, because they're guardians and not parents?
Correct. Under MCL 700.5215, it's the guardians are not liable to the support of the child, nor are they liable to third persons under 3.915E. It says that the parents are liable for they're liable for their own attorney fees for sure. And then if you're talking about a juvenile, the person represented is responsible for their own representation unless there's somebody responsible for them. In this matter, the guardians are not responsible for the parents in any way, shape, or form. In Tilley versus Tilley, the parents are responsible for the children, not the guardians. I mean, there's no statute, there's no court rule under MCL 712A.25 regarding payment of expenses. If they're indigent, it says, except as otherwise provided by law, expenses incurred in carrying out this chapter shall be paid upon the court's order by the county treasurer from the county's general fund. You can imagine if guardians or anyone for that matter, because petitioners could be guardians, they could be anyone intervening on behalf of a child. You can imagine what would happen if they were told that they were going to be responsible not only for their attorney fees, but also the attorney fees of both parents, an LGAL, a GAL. The interest of the child would be lost in that. Nobody would be able to nobody would be able to help them. I mean, I have a list of 47 consequences, public policy arguments that I could go through, that it would be, besides that, the cost to the state would end up actually being higher, because they would, people would not be able to they wouldn't be able to take in their own nieces, nephews, grandchildren, if they didn't have any money, and they would turn them over to the state and the state would take them anyway. But there's no, I could not find any court rule, any statute, any case law, no authority whatsoever to make the guardians responsible. And having said that, the guardians in this matter have had the child almost since birth. The mother has not, the mother was actually right before just the end of the summer, the mother was arrested because she owed an excess of $27,000 in child support, hadn't paid any. So my clients downstairs were the victim because for not receiving any of the child support is being owed to them. Yet upstairs in the probate court, they were threatening to hold them in contempt for not paying the mother's attorney fees. I can't imagine what would happen to children if people stopped intervening on their behalf. I can't imagine the cost to the state, for sure. I can't find a law. The trial court stated that it could not find a law either that would allow it to do it. They just said that this is our policy and this is what we always do. The laws apply to whoever's the petitioner. The law does not differentiate between petitioners. So whether the petitioner is a neighbor, an aunt, an uncle, a grandparent, an older sibling, the rules are the same. But the parents are responsible if they there's required to be a hearing. The parents have to request an attorney first. They have to be deemed indigent second. So there has to be a hearing on that or some documentation. And it's usually done at a preliminary hearing. We have not even had any of that. So this is all being assessed in a guardianship case. We haven't had a preliminary hearing in the neglect and abuse case. It's been on hold. We haven't even had that yet. And so the parents are responsible for the children. The parents are responsible for the children, frankly, even after a neglect and abuse case. If their rights are terminated, they're still responsible for child support unless and until the children are adopted.
Do you know if this is a widespread practice or is it just this judge's policy?
Well, that's a good question because I did ask on the listserv and it seems to run, I'm going to say it's running about 50-50 because I've had a lot of attorneys say, oh yeah, that's how it's done. I can tell you this, I've had no one say, yeah, they can't do that. So to me, it's like, it's almost like it's accepted. No one has brought it forth to the court. No one's appealed it because people don't have the money to file the appeal, frankly.
All right,
in our case where we're at, the neglect and abuse is on hold because my clients can't afford to go forward with it if they are going to have to pay for everyone's attorney fees. They just can't. And right now they're just getting notices, which the other thing is I'm not even getting the notices. The court says that they don't provide notices to attorneys when they're assessing fees against their clients and sending them threats of contempt for non-payment. So apparently we don't get those orders either. I'm not sure where that came from. I did ask for a policy or a rule or something, because to my knowledge, an attorney in a case gets a copy of every document, apparently except that one. So I won't go into public policy arguments, but I think that the court can imagine them. If anybody has any questions, I'll go through them, but I think they're obvious.
Any questions? Thank you very much. Appreciate your appearance and your argument, and we'll submit that and get an opinion to you quickly.
Okay, thank you.
Hey, have a good day.
You too.
The last two items on our call are going to be submitted on the briefs. Let me read them into the record. Item 13, case number 373195, in re Catherine Plank Revocable Trust. No one has preserved argument. And number 14, case number 375684, in re KS Baker Minor. Both of those will be submitted on the briefs. That concludes our case call for today.